Hello, good morning, and welcome to Byjus Exam Prep. Yesterday, we initiated a discussion on the Keshavananda Bharati judgment and the doctrine of basic structure. Keshavananda Bharati, a young head of a mutt, a religious body in Kasargod district in Kerala, he approached the Supreme Court. And along with him, there were various other petitioners as well. But since he was the first one to approach the court, the case came to be known as the Keshavananda Bharati case. This is considered to be a landmark case in the history of independent India. It was heard by the highest number of judges, 13 judges at that time, which is still the highest strength of the Supreme Court. This judgment was in 703 pages. The Attorney General, who presented the government story saying Parliament has the power to amend any provision of the Constitution, 71 constitutions were compared. And this case was heard for the 68 days, which is still a record. After that, we saw the case being heard for 42 days, for example, the Ayodhya judgment. Then we saw the right to privacy judgment, which was heard for 40 days. So still 68 days is a record, which no other case has breached. And the fundamental question before the court was, is the power of Parliament supreme? That it can amend any provision of the Constitution. Shankari Prasad Deo case, 1951, the Supreme Court said, yes, law is different under Article 13 and Constitutional Amendment Act is different. That means through an ordinary law, you cannot delete, modify, abridge fundamental rights, but through Constitutional Amendment Act, passed under Article 368, you can amend any fundamental right. This position of the Supreme Court was reversed in an 11-judge bench case known as the Golaknath case. Supreme Court said no. The definition of the law under Article 13 includes Constitutional Amendment Act. Because when Article 13 Clause 2 says the state cannot make any law, this any law expression includes a constitutional amendment. That means even through Constitutional Amendment Act passed under Article 368, Parliament cannot delete, modify, abridge fundamental rights. If you want to touch and disturb fundamental rights, you may set up a constituent assembly. And that constituent assembly will use the procedure mentioned under Article 368 to amend the Constitution. Parliament only has the ordinary legislative power. It does not have a constituent legislative power. It cannot amend fundamental rights. Fundamental rights are beyond the amending powers of the Parliament. And in fact, Golaknath case, Supreme Court said, look at the title of Article 368. It does not give Parliament the power to amend the Constitution. It only talks about procedure for amendment. And this procedure should be followed not by the Parliament, but by the Constituent Assembly, which may be set up to amend fundamental rights. Judicial interpretations vary. But then this defeat in the Golaknath case was not to be taken lightly by the government. Then series of actions were taken by the Parliament, beginning with 24th Amendment, which said any constitutional amendment bill, when it is presented to the President has only one option: sign that constitutional amendment bill. Another change Article 31 capital C was added, which basically gave primacy to two directive principles over three fundamental rights. That means even then, through constitutional amendment, fundamental rights were modified, abridged. Privy purses was abolished. Which was the promise of Sardar Patel to these princes, that you give up your sovereignty, instead we will give you a privy purse. No questions asked. You spend the money where you want to spend. Even this privy purse was abolished. 1969, banks were nationalized. Fourteen private banks were nationalized by the government. When 14 banks were nationalized by the government, a petition was filed in the Supreme Court. And that case was led by Nani Palkhiwala. And Nani Palkhiwala won this case. The Supreme Court said the way these banks were nationalized is unconstitutional. Why? Supreme Court did upheld the right of the government to take over the management of the industry, to take over the management of a factory, to acquire land or estate. But for that, you have to pay compensation because right to property is still a fundamental right. The government said we are giving compensation to these owners of 14 private banks. But the court said you are paying them compensation in the form of bonds. These bonds would mature after 10 years. So this is not a fair compensation. Hence, it violates Article 31. Nani Palkhiwala won the case. The government was defeated. Then when privy purses was abolished, Madhavrao Scindia, one of the beneficiaries of the privy purse, his son right now is a minister for civil aviation, previously with Congress, now with the BJP, tomorrow with my party. But be that as it may, Madhavrao Scindia also approached the Supreme Court, challenged the abolition of privy purses. Nani Palkhiwala was the lawyer. Nani Palkhiwala defeated the government. That means government was under a series of pressure by the judiciary, where judiciary was striking down one by one various important policy decisions and laws passed by the parliament. But then the government did something else. Kerala government had passed a law saying we can acquire land, we can acquire property, even if it belongs to religious communities, even if it belongs to a private person. If we want to distribute this wealth, if we want to ensure better management of that industry. But somebody advised Kerala government that you can't do this, because if you do this, maybe Nani Palkhiwala will go to the court. The Kerala government said, then what do we do? Kerala government was advised, you approach the central government, let the central government introduce or include this Kerala Land Reforms Act in the 9th schedule of the Constitution. And any law which is placed in the 9th schedule of the Constitution is immune from judicial review. Judiciary cannot question that particular law. Previously, what had happened, privy purses was abolished through an executive order. Listen to me carefully. Privy purses was abolished through an executive order. How? Indira Gandhi's government issued an order that all these princes, they are no longer princes. When they are no longer princes, which means they are not entitled to the privy purse, which is mentioned in the Constitution. The Supreme Court said, based on the arguments given by Nani Palkhiwala, saying through executive order, you cannot do this. You cannot violate the rights of the princes. And when the banks were nationalized, Supreme Court upheld the right of the government to nationalize the banks, but by saying that you have to provide fair compensation. And this compensation, which you are paying in the form of bonds, and these bonds will mature after 10 years, this is not a fair compensation. But then, when this Kerala government's law, when the law passed by the Kerala legislature, Kerala Land Reforms Act, which basically took away the land, took away the private property of individuals for their benefit, presumably, this law was placed in the ninth schedule. And one individual who got most affected because of this was Keshavananda Bharti. Keshavananda Bharti was a young head of a mutt in Kasaragod district in Kerala. He wanted to approach the court. Judicial literacy. He was aware that they have got some rights. He wanted to approach the Supreme Court. Somebody advised him that you should include Nani Palkhiwala. Get in touch with Nani Palkhiwala. He has defeated the government multiple times. He should be in a better position to help you. When somebody advised Nani Palkhiwala met some of the representatives of Keshavananda Bharti. But the beauty is, Keshavananda Bharti and Nani Palkhiwala never met. This is perhaps a rarest of the rare cases where the petitioner is not meeting his own lawyer, but through other advisors of Keshavananda Bharti, they used to get in touch with each other. And Nani Palkhiwala advised Keshavananda Bharti that we should approach the court on the grounds of violation of Article 26. Article 26 gives the fundamental right to every religious denomination that you can establish and administer religious institution, whether for religious purposes or charitable purposes. You can acquire movable or immovable property. But through this Kerala Land Reforms Act, your movable or immovable property can be acquired by the state, for which you will not be provided any compensation. Keshavananda Bharti, he was also the owner of various coal, sugar companies as well. All those would have been adversely affected because of this Kerala Land Reforms Act. And on the advice of Nani Palkhiwala, a petition was filed challenging the introduction of Kerala Land Reforms Act in the ninth schedule, as well as challenging the right of the parliament, the right of the legislature to violate fundamental rights. And since Keshavananda Bharti was the first one to approach the court, the case came to be known as the Keshavananda Bharti versus State of Kerala. But then previously, when Indira Gandhi's government had issued an order saying these are no longer the princes. When you are not princes, that means you are not entitled to the privy purse. Since this was struck down by the court, now another constitutional amendment act was passed, 26th constitutional amendment. And through amendment to the constitution, privy purses was abolished. Mother of India approached the Supreme Court again, luring in Nani Palkhiwala, please help us. Similarly, 31 capital C, when it was introduced into the constitution, it was also challenged in the Supreme Court. And various other cases, various other petitioners approached the court. And when Supreme Court looked at all these petitions, Supreme Court said it is better that we club all these petitions together and hear them together. Why? Because all these petitions raise one common fundamental seminal issue and question, which is the power of Parliament supreme, that it can amend any provision of the Constitution? And what transpired later on was one of the brilliant legal minds this country has ever produced, Nani Palkhiwala. And Nani Palkhiwala thundered before the court. And he spoke of something called implied restriction. What is implied restriction? The plain reading of the Constitution. When you read the Constitution, it did not contain any restrictions on the powers of the Parliament. Yes, we may say that there was a restriction vis-a-vis fundamental rights. Article 13, state cannot make any law to delete, modify, abridge a fundamental right. But apart from that, Parliament had the power to amend any other provision of the Constitution. There was no restriction on the powers, on the amending powers of the Parliament. Nani Palkhiwala argued before the court, my lord, there is an implied restriction. Implied restriction in the sense, not explicitly are there restrictions on the parliament, but implicitly there are. There are some things that parliament cannot do. The court asked, what are these things? Nani Palkhiwala said, let's assume for a while. Let's assume for a while that the power of the parliament to amend the constitution is supreme. Parliament can amend any provision of the constitution. Let's also assume that law is different and a constitutional amendment act is different. Through an ordinary law, you cannot delete fundamental right, but through a constitutional amendment act, you can delete a fundamental right, abridge a fundamental right, modify a fundamental right. Does that mean, my lord, Parliament can use Article 368 and say tomorrow you do not have freedom of speech and expression? This is not the fundamental right that you have. If Parliament uses Article 368 to amend the Constitution, because through a Constitutional Amendment Act, it can delete, modify, abridge a fundamental right, will you allow tomorrow for this Parliament to amend the Constitution and say citizens do not have freedom of speech and expression? Is it not an implied restriction that Parliament should not do this? Or let's take it a level further. Can tomorrow Parliament pass a law, a Constitutional Amendment Act, saying we will delete Article 21? There is no life and personal liberty. Can you allow Parliament to do that? Is there no implied restriction? Let's go a step further. If Parliament has the power to amend any provision of the Constitution, does that mean tomorrow Parliament can give this country back to Britain? Parliament can convert this republic constitution into a monarchy? Parliament can convert multi-party democracy into a single-party democracy, saying only one political party will exist, Indian National Congress. All other political parties are banned because Parliament can do anything if they have the majority in the Parliament. Or let's take it a step further. Constitution says the term of Lok Sabha is 5 years, isn't it? Term of Lok Sabha is 5 years. That means every 5 years there shall be elections in India. If Parliament has the power to amend any provision of the Constitution, and this power is supreme, unrestricted, can tomorrow a government which has the brute majority in Parliament, which has a majority in the Parliament, convert this or change this 5 years into 5,000 years? Saying the term of the Lok Sabha is 5,000 years, for 5,000 years we will have no elections in this country. Can Parliament be allowed to do all this? Can Parliament be allowed to modify, to abridge some of the basic structures of the Constitution, some of the basic fundamental features of the Constitution? And by the majority of 7:6, Supreme Court upheld the power of the Parliament, saying yes, Parliament has the power to amend the Constitution, save the basic structure. Yes, Parliament has the power to amend any provision of the Constitution, but not the basic structure, does not alter the basic structure. And what is this basic structure? If I can give you a real life example or a daily example, this is the studio from where I'm taking the class. Can I change the stylus I'm using to write on the screen? I can. Can I change the screen itself? Yes. Can I change the teacher itself? Yes. Can I change the AC of this room, the color of this room? We can do all these things. But can I change and destroy the foundation on which this building is standing? I can still do that. But then it won't be the same building, it will be something else. Similarly, in Constitution, there are some basic pillars on which the entire constitution rests. Those features you should not alter. Those features you should not change. Any other thing, any other provision which is not the basic structure, you can change, you can alter, you can modify, you can amend. Because if you alter the basic features, fundamental features of the constitution, then our constitution will not remain the same, it will be something else. And how can we give this power to the parliament? Because this parliament has been created by the constitution. How can the creator be destroyed by an institution which creator created? So it is this constitution which created this institution called parliament. How can parliament destroy the same institution which created it? You can amend the features, other features, allied features, without altering the basic structure. And in fact, this judgment way back in 1963, it was Justice Mudholkar who had basically spoken of fundamental features, saying there are some fundamental features which parliament should not destroy, parliament should not alter. But that was a minority view, just like in day before yesterday's judgment, there was the minority view of Justice Chandrachud and Justice Kaul, wherein they said, yes, LGBT community, they have the right to adopt children. But that was a minority view, because the majority view said, no, they can't even adopt the children. So it was a minority view of Justice Mudholkar in 1963, wherein he had said that Parliament does not have the unrestricted power to amend the constitution. It cannot violate basic structure or fundamental feature. And in fact, Justice Mudholkar was referring to a Pakistani Supreme Court judgment which was given 8 years ago. So 1955, the Pakistani Supreme Court, headed by Justice Cornelius, he had spoken of something known as the fundamental features of the constitution, saying Pakistani parliament should not alter the fundamental features. And same thing was quoted by Justice Mudholkar in 1963. And later on, what Supreme Court said in 1963, what Justice Mudholkar said in 1963, the same thing was reiterated by 7 judges in 1973, saying Parliament does not have the power to violate basic structure. But is this doctrine good or bad? Let's take a look at the arguments against this judgment. Number one, this doctrine of basic structure, it is a judicial innovation. Yes, power is with the Supreme Court to interpret the Constitution. But if I were to ask you, is judicial review mentioned anywhere in the Constitution? No. The job of the judiciary was specific with fundamental rights, saying if Parliament restricts fundamental rights, if the state violates your fundamental rights, you can approach the Supreme Court under Article 32 and Supreme Court will protect and uphold your fundamental rights. Apart from that, there was no such expressive power given to the Supreme Court that you have the power of judicial review. Every act of the executive, every act of the legislature, you can review. And now it has innovated this doctrine of basic structure, which is not found anywhere in the Constitution. Where is this term basic structure mentioned in the Constitution? And how can Supreme Court add terms to the Constitution, saying this is part of the basic structure, others are not, and you cannot impose any restrictions on the basic structure? This is a judicial innovation. Second, goes against the arguments of Dr. Ambedkar and Pandit Nehru. What did Dr. Ambedkar say regarding the Constitution? I am sure most of you or some of you will not be satisfied with the Constitution. If you're not satisfied with the Constitution, all you need to do, get two-third majority in the parliament and change the Constitution. That means Dr. Ambedkar did not say get two-third majority and change other features of the Constitution other than basic structure. He did not say this. So the architect of our Constitution is giving power to the parliament that if you have the majority, you can change the Constitution the way you want to. And that's what Pandit Nehru also said. Pandit Nehru said any popular demand should be capable of realization. Any popular demand. That means no restriction whatsoever. For the sake of argument, don't say or don't consider that I believe in this, but this is just for the sake of the argument. Let's say there is one section of the society, whether that's a minority or majority, let's not get into that. Let's say there is a section of the society which believes that in 1947 the country was partitioned on religious grounds. And a country was given to Muslims called Pakistan. And now whatever else is remaining, this should be a Hindu country. This should be a Hindu Rashtra. Let's assume for a while that these people who think along these lines, they become majority. And now they have the majority in the parliament as well. That means majority of the people of this country, through their representatives in the parliament, they want to convert India from a secular state to a Hindu Rashtra. Why should this not happen? Why? Because Pandit Nehru said any popular demand should be capable of realization. But this cannot happen because the Supreme Court has said there is something called basic structure. Secularism is part of the basic structure. So this country can never become a Hindu Rashtra. I'm not saying it should become a Hindu Rashtra or it should not become a Hindu Rashtra. All I'm saying is, how can judiciary decide what is the basic structure of the Constitution? How can judiciary impose a restriction which did not exist in the Constitution in the first place? Because if the makers of our Constitution said any popular demand should be capable of realization, one such demand may be a Hindu Rashtra, why it cannot be achieved? Because basic structure imposes a limitation on this. Third, there is no rigid list. Supreme Court did not say in 1973 that this is what constitutes basic structure. Supreme Court said rule of law is basic structure. Supremacy of the Constitution is the basic structure. Importance of fundamental rights is part of the basic structure. Separation of powers is part of the basic structure. After that, Supreme Court said the Supreme Court itself will further add basic structures to this list. That means what is basic structure? That is for the Supreme Court to decide. And Supreme Court keeps on adding items into this basic structure. So this is not a rigid list. It is not that in the same judgment Supreme Court said this constitutes basic structure. It keeps on adding items to this basic structure. Later on saying secularism is part of the basic structure. Federalism is part of the basic structure. Balance between fundamental rights and directive principles is part of the basic structure. Independence of judiciary is part of the basic structure. And then came something interesting. NJAC was passed by the government, by the parliament in 2014. What is NJAC? We'll discuss that in judiciary, but very briefly here. Today, there is something known as the Supreme Court Collegium, consisting of Chief Justice of India and 4 senior judges of the Supreme Court, which recommends names to the President that these are the individuals you should appoint to High Court, you should appoint to Supreme Court as judges. Which makes India the only country in the world where judges are appointed by themselves. That means I'm the Chief Justice, I have 4 colleagues, we recommend name that this person should be appointed as a judge. And only you can be appointed. President does not have any other choice. That means basically my recommendation becomes the judge. That means judges are appointing themselves. In 2014, Mr. Modi came to power, called the parliament and said, Mitro, we need to change this. Said, yes, sir, we need to change this. And there was a unanimity in the parliament, consensus in the parliament, that we should replace this collegium system with a body known as National Judicial Appointments Commission. And it's not that this NJAC would have been dominated by executive, would have been dominated by parliamentarians. This NJAC consisted of Chief Justice of India, 2 senior judges of the Supreme Court, law minister, and 2 eminent persons. So in this NJAC, we have the members from the judiciary, Chief Justice and 2 senior judges. From the executive, law minister. From civil society, 2 eminent persons who are eminent in some walk of life. Maybe I would have been part of NJAC, who knows? For the sake of humor. That means now this collegium, which functions in an opaque manner, we don't know how these judges decide that this particular judge should have been appointed, this particular individual should be appointed as the judge. This working of collegium is very opaque. That is why perhaps Justice Chandrachud, who is now the Chief Justice of India, with due respect to him, is a fantastic judge, but his father was also the Chief Justice of India. And there have been so many judges whose fathers have been Chief Justices as well, or whose fathers have been important members of the bar, the top lawyers or the advocates. Justice Rohinton Nariman, fantastic judge, but his father, Falias Nariman. Now the Supreme Court Collegium had recommended Mr. Kirpal, Saurabh Kirpal, as the judge of the Delhi High Court. His father was also the judge. And his father was the Chief Justice when Justice Chandrachud was nominated to the Supreme Court. So maybe when we criticize dynasty in politics, when we talk about some Bollywood heroes and actors and actresses as Nepo kids, there are Nepo judges as well. So it's like circulation of elite, which takes place. That is why perhaps it was right that this collegium system should be replaced by a more consultative body, which has the members from the judiciary, from the executive, from the civil society, known as NJAC. This NJAC was challenged in the Supreme Court. And Supreme Court said NJAC is unconstitutional. On what grounds? Supreme Court could not say, and could not only say independence of judiciary is part of the basic structure. Because somebody would have caught hold of this judge and said, please come to me and tell me, how does NJAC violate independence of judiciary? Please tell me. You have 3 members in NJAC. The government is only 1. And you have 2 eminent persons. In fact, these 2 eminent persons will be selected by Chief Justice of India, Prime Minister of India, and Leader of Opposition in Lok Sabha. So you can gang with the Leader of Opposition and the Chief Justice, and you will have your own nominees, even if Prime Minister does not agree with these names. So how can you say independence of judiciary is violated? Supreme Court decided, let's invent another basic structure. And what is that another basic structure? Primacy of Chief Justice of India in judicial appointments. And do you know what is this primacy of Chief Justice of India in judicial appointments? Today, Chief Justice of India has a veto. What is that veto? When the Collegium, Chief Justice of India and 4 senior judges of the Supreme Court, they decide upon a particular name. If they have decided my name, that Sarmat should be appointed by the President as the judge of the Supreme Court. If 4 judges say, yes, he's a good candidate, but Chief Justice of India said, no, in his polity lectures, he has criticized me, I will not accept his name. if Chief Justice of India says, no, my name cannot be sent to President for appointment, that means any name which is not acceptable to Chief Justice of India cannot be sent by the collegium to the President, which means Chief Justice enjoys a virtual veto. And that is what Supreme Court calls primacy, because veto word would have been very annoying for people to understand. And now they replaced it with primacy of Chief Justice of India in judicial appointments, saying if this is the body, Chief Justice does not have the veto. So any name which is not acceptable to Chief Justice of India can still be nominated to the Supreme Court, provided other members agree. Since Chief Justice does not have the veto, which is what they call euphemism, primacy of Chief Justice of India in judicial appointments, this is also part of the basic structure. So the problem with this doctrine is, one, it is a judicial innovation. It does not find mention in the original constitution. Second problem is, it goes against the philosophy of the founding fathers of our constitution, saying any popular demand should be capable of realization. It did not say subject to basic structure. Dr. Ambedkar said, get two-thirds majority, change the constitution. He did not say subject to basic structure. And what is this basic structure? This list keeps on adding, because it is not the one-time exercise by the court. They do not sit once and decide, let's read the entire constitution and pick what are the basic structures. As and when the cases approach, you decide what else is part of the basic structure, sometimes benefiting yourself as well. Primacy of Chief Justice of India in judicial appointments is also part of the basic structure. And this basically leads to tyranny of unelected on the elected. Parliament, whether you agree with it or not, but it is your body. Your body in the sense, every 5 years you come out in large numbers, exercise your right to vote, get your people elected, and these people will then make laws for you. So basically, it is not these 543 MPs in Lok Sabha who are sitting. It is the collective majority of the people who is sitting inside the Lok Sabha, because they represent you, directly represent you. That means that when the law is passed by the parliament, this is not the law passed by the parliament, this is the law passed by the people of this country through their representatives, because these representatives are elected by the people. And these representatives are accountable to the public as well. If you don't like a particular law passed by the parliament, tomorrow when these people will come to you begging for votes, you can throw them out. No, we will replace you with someone else, because we don't like the law which you have been passing in the parliament. Basically, parliamentarians are accountable to the public, responsible to the public. That is why every 5 years they come up with folded hands before you. Please vote for me. I promise now I will be regular in the constituency. I was not present for the last 5 years, but this time please protect me, save me. Take 20,000 rupees. Be that as it may. But the same law which is passed by the parliament, basically reflecting the will of the people, goes to the Supreme Court, and Supreme Court strikes it down. Who are these judges? With due respect, you're not accountable to anybody. Who are these judges? Unelected. So this is leading to tyranny, a rule of unelected over the elected in the parliament. That is the problem with this doctrine of basic structure. But then there are others who say no. If Sachin Tendulkar saved India's cricket, it is this Keshavananda Bharati judgment that saved Indian democracy. How? For that, let's take some examples. Let's not let's not take a hypothetical route that if there was no basic structure, this would have happened. Unless and until we see a clear danger of that happening. Let's look at the examples which basically happened. 39th and 41st Amendment. Pandit Nehru was the Prime Minister. India-China war broke out. India was defeated. Pandit Nehru passed away. Then came Lal Bahadur Shastri as the Prime Minister. Did something well. In fact, Pakistanis would criticize him. Pakistanis would look down upon him. That is why they waged a war against India in 1965, saying this very short built, thin built, with very weak physique, how can he protect his country? And then Lal Bahadur Shastri taught them a lesson and defeated Pakistan vehemently. But unfortunately, he died in mysterious circumstances at Tashkent. After the death of Lal Bahadur Shastri, now the question arose, who will become the Prime Minister? Morarji Desai, he was the senior member of the Congress party, was very happy that now I will become the Prime Minister. Finally, my time has come. But instead, the Congress chose Srimati Indira Gandhi as the Prime Minister, saying, you take up your father's legacy and assume the post of the Prime Minister of India. Morarji Desai, he laughed at this idea. How can Indira Gandhi become the Prime Minister? She is Gungi Gudiya. She can't speak. This doll can't speak. So how can she become the Prime Minister? But this Gungi Gudiya became Durga in 1971. When in 1971, India defeated Pakistan, which led to the emergence of Bangladesh as an independent entity. And at that time, the president of the Congress party, he was from Assam. He said, India is Indira. Indira is India. There is no difference between the two. Just like today, members of the hardcore members of the government and their supporters say, Modi is India, India is Modi. And you would have read that people always talk about some similarities between Indira Gandhi and Mr. Modi. Whether right or wrong, we don't know, but Ms. Indira Gandhi was the most powerful prime minister at her time. And in 1971, after the defeat of Pakistan in the India-Pakistan war, which led to the emergence of Bangladesh as an independent country, she advised the president, please dissolve Lok Sabha. Why dissolve Lok Sabha? Let's have fresh elections. Why? Because the rod is very high right now. The iron rod is, what do we call it? Loha garm hai. Why? Because few years ago, Congress party got split. This Congress party, because of the manner in which Indira Gandhi was running the government and running the party got split. And some members, important members of the Congress party, they left. Which means the number of strength of the Congress in Lok Sabha reduced. Now she has a separate political party, Congress I, Indira's Congress. She wanted to reap the benefits of the Bangladesh emergence or the defeat of Pakistan in 1971 war. She advised the president, dissolve Lok Sabha. Lok Sabha was dissolved, fresh election was conducted, and Congress won by the thumping majority. Because you reap the benefits of the popular sentiment in your favor. And Indira Gandhi herself won the election from Rai Bareli constituency in UP. And she defeated her opponent Raj Narayan. And Raj Narayan later on approached the Allahabad High Court. Saying Indira Gandhi should be disqualified not Chikmagalur. Chikmagalur she contested in 1980. after she was defeated in the 1977 elections. Then riding an elephant, she went to Chikmagalur and won the election there. We are talking about 1971 elections. The petitioner Raj Narayan approached the Allahabad High Court and said Indira Gandhi should be disqualified. Why? On the grounds of electoral malpractice. What is electoral malpractice? Raj Narayan alleged that dear Allahabad High Court, Indira Gandhi has used government machinery for her votes. How? She has used her government officers, government employees to campaign in the elections. You can't do that. That's an electoral malpractice because government employees cannot be used for party politics, for campaigning for the elections, for canvassing for votes, for asking for votes. You can't do that. Indira Gandhi has also used the government machinery. For example, government vehicles or vehicles were used whose funding was given by the government to ferry voters from their homes to the constituency. So government vehicles, government cars were used by the political party in power to bring voters from their homes to the constituency. This amounts to electoral malpractice, which is a corrupt practice under the Representation of the People Act 1951. And the decision should be Indira Gandhi should be disqualified from Lok Sabha. Which means when she is disqualified from Lok Sabha, it basically means she will no longer continue as the Prime Minister. Allahabad High Court said, Raj Narayan, you are right. Indira Gandhi, you are disqualified. And she became the first sitting Prime Minister to be disqualified from Lok Sabha. But immediately, once she was disqualified, Indira Gandhi approached the Supreme Court. That's how you do. You are sentenced by one court, you quickly move the High Court or the court above, which is Supreme Court, asking for a stay on the High Court's judgment. Indira Gandhi, through her lawyers, approached the Supreme Court. Supreme Court was asked, please impose a stay on this judgment. Supreme Court said, yes, this is a sensitive matter. We are imposing a stay on this judgment. Indira Gandhi got happy. But the court said, Madam Gandhi, wait. You can't vote inside Lok Sabha till the time we decide whether you should be disqualified or not. That means we are basically saying this judgment of the Allahabad High Court will not enter into force, which means you will not be disqualified. But we still have to decide whether you are guilty or not. Till the time we decide whether you are guilty or not, you can't vote inside the Lok Sabha. Indira Gandhi then added another first to her name. She became the first Prime Minister to not be allowed to vote in the Lok Sabha. But then when the Supreme Court kept on hearing this case, she realized, her advisors also advised her, that maybe Supreme Court will rule against you. You will become the Prime Minister. You are the Prime Minister, but you will be disqualified. And very soon, in June 1975, what Indira Gandhi did, imposed emergency. And today, writers, activists, historians, they say one immediate trigger of imposing emergency in 1975 was this Raj Narayan verdict of Allahabad High Court and this expectation, this nervousness on part of Indira Gandhi that she may be disqualified by the Supreme Court. Emergency was imposed in 1975. And when emergency was imposed, Constitution was amended multiple times. That is why you will hear about 42nd Amendment multiple times, which is considered to be the mini revision of the Constitution. But for the sake of the discussion of the topic that we are discussing right now, we will discuss two amendments which took place, 39th Amendment and 41st Amendment. And what happened because of these amendments? 39th Amendment said, no case can be filed against President, Vice President, Speaker of Lok Sabha, Prime Minister, irrespective of any electoral malpractice. Madam Gandhi, let's impose emergency. Very good. Then, sorry. Let's impose emergency. Then, let's amend the constitution. The Supreme Court wants to disqualify you on the grounds of electoral malpractice. Let's amend the constitution and say President, Vice President, Speaker, Prime Minister, their election cannot be challenged on the grounds of electoral malpractice. Very good. But somebody else told Indira Gandhi, Madam Gandhi, this amendment would save you now. But tomorrow, if you're defeated in the elections, after that, they will drag you. After that, they will arrest you. So you'll have to do something after you cease to be the Prime Minister. Don't worry. Let's have 41st Amendment. No case, whether civil or criminal, can be filed against Prime Minister, Governor, President, even after they demit office. That means they can't do anything to me even after I cease to be the Prime Minister, because even after I exit the post of the Prime Minister, no case, whether civil or criminal, can be filed against me. Which basically means if you are governor of a state even for a day, you enjoy immunity for your entire life. No case can be filed against you. Both these amendments were challenged in the court. Both these amendments were challenged. Now let's go back to the same question. If the power of the parliament is indeed supreme, that it can amend any provision of the constitution, there was no way for the Supreme Court to say that 39th Amendment, 41st Amendment is unconstitutional, because Parliament can do anything. But since there is something called basic structure, what Supreme Court said? Supreme Court said both these constitutional amendments are unconstitutional. On what grounds? That they violate basic structure. Rule of law is part of the basic structure. When you say that you cannot be disqualified irrespective of electoral malpractice, that means for president, for vice president, for speaker, for prime minister, there exists no law. When you are saying no case, whether civil or criminal, can be filed against prime minister even after she demits the office, it violates free and fair elections, which is also part of the basic structure. And both these amendments were declared unconstitutional by the Supreme Court, thanks to the doctrine of basic structure. If there was no such thing as basic structure, 39th Amendment would have continued in the Constitution. 41st Amendment would have continued in the Constitution. Then would India have survived as a democracy? No, it would have been degenerated into one party rule or one woman rule or one man rule. In fact, Mr. Sirvai, he was representing the government of Kerala in Keshavananda Bharti case. He later on accepted that yes, it is indeed the doctrine of basic structure which has saved India's democracy. Parliament can amend any provision of the constitution, but there are some foundational blocks, building blocks of our constitution which cannot be altered even by using Article 368. That is the doctrine of basic structure. Any questions as of now? Sir, can criminal case like murder also not be filed against president or governor while they are in power, even if there is evidence? You can't file a criminal case during the time when president or the governor is in office. Once they demit the office, you can file that case. Is during emergency Supreme Court is working or not? Supreme Court is working. Why doesn't the court tell at once what constitutes basic structure? Because it has to evolve over a period of time. Supreme Court cannot rule on hypothetical matters. Supreme Court can rule on only those matters which are presented to it. So if it's a matter related to elections, on elections, free and fair election are part of the basic structure. That's what the Supreme Court can say. Supreme Court cannot refer to any other part and say in fundamental rights, this is part of the basic structure. Supreme Court can only rule on a matter which it is presented with. Okay. Now we know that Parliament has the power to amend any provision of the Constitution except what is part of the basic structure. Now let's look at what is the procedure that Parliament has to follow to amend the Constitution. And the procedure is there has to be a bill. What is a bill? Bill is a proposal. What is the proposal? The proposal is to amend the Constitution. The proposal is to add something to the Constitution, delete something from the Constitution which is not a basic structure. That is a bill, that is a proposal. Look at the chronology and please listen to me carefully. If this is clear, then no question becomes difficult for you when it comes to the prelims exam. This bill can be introduced where? First in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. This bill can be introduced in either of the two houses of the parliament. Can be introduced first in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then Lok Sabha, doesn't matter. Can be introduced in either of the houses of the parliament. Yes, it has to be passed by both houses, but where do we introduce it first? Either Lok Sabha or Rajya Sabha. But who can introduce this bill? If there is a bill which can be introduced by a minister or which can be introduced by a private member, this bill becomes a government bill. This bill becomes a private member's bill. Who is a minister? Who is a private member? Let's talk about Lok Sabha, or let's talk about Rajya Sabha, or let's talk about both. In Lok Sabha, we have some ministers, Mr. Amit Shah, Mr. Modi, Ms. Smriti Irani. These are ministers. Any bill which is introduced by them becomes a government bill because these are ministers who are part of the government. But inside Lok Sabha, we have Varun Gandhi as well. Inside Lok Sabha, we have the superstar of Gadar 2, Sunny Deol as well. If at all he decides to attend the parliament, God forbid, and he presents a bill inside the parliament, that bill would become a private member's bill. Why? Because although Sunny Deol is part of the BJP is part of the government. But since Sunny Deol is not a minister, and thank God he's not a minister, and when Sunny Deol is not a minister, he becomes a private member. Any non-minister becomes a private member. When Rahul Gandhi introduces a bill, because he's not a minister, it becomes a private member's bill. That means any bill which is introduced by a minister becomes a government bill, introduced by a non-minister becomes a private member's bill. For example, in Rajya Sabha, we have Mr. Piyush Goyal. He's a minister. Any bill introduced by this minister becomes a government bill. But we have Mr. Mallikarjun Kharge as well. He's not a minister. Any bill introduced by him becomes a private member's bill. And this constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha. By whom? By a private member or by a minister. Anybody can introduce a constitutional amendment bill. But we discussed in Article 3 that when a bill under Article 3 is to be introduced in the parliament, prior sanction of the president is required. What is that bill? Bill which talks about reorganization of the state. A bill which talks about division of state, merging of state, changing the name of the state, increasing the area, decreasing the area, altering the boundaries of that state. When that bill is to be presented before the parliament, first prior sanction of the president is required. Without president's prior sanction, you cannot introduce a bill in the parliament under Article 3. But this constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha. By whom? By a private member or a minister. And prior sanction of the president is not required. And then this bill should be passed by each houses of the parliament by special majority. And what is that special majority? Something we have discussed previously. 2/3 of the members present and voting plus majority of the total membership of the house. That means both the conditions should be satisfied. This bill, if it is introduced in Lok Sabha, should be passed by Lok Sabha by special majority, which means by the majority of 2/3 members present and voting, plus majority of the total membership of the house. And then this bill will be sent to Rajya Sabha. And in Rajya Sabha also, it should be passed by the special majority. Normally what happens, if one house passes a bill and the other house does not pass that bill, rejects that bill, we say that there is a deadlock. Deadlock in the sense, for example, we have two batches of students. Batch 1, batch 2. Batch 1 has 300 students. Batch 2 has 100 students. Now I'm telling my students that maybe I will not be able to complete the syllabus in 25 classes. I need 2 extra classes. And my proposal is, let's have these 2 extra classes on Saturday and Sunday. Or my proposal is that Saturday and Sunday we will extend the duration of the class. We will cover the classes in 5 hours instead of 3.5 hours. You tell me whether we should do this or not. But this proposal should be passed by both the batches. Majority in batch 1, they say, yes, we agree. Let's have extra classes on Saturday and Sunday. Batch 2 says, no, we reject this. We can't have classes on Saturday and Sunday because there is Cricket World Cup. We have to go out for movie. We just have to sleep, whatever the reason may be. That means one batch is approving this proposal. The other house is not approving. What happens? There is a deadlock. I don't know what to do. So I'm telling you, please sort it out amongst yourself. Tell me what to do. I'm okay. I'm okay with anything. I'm even okay that I can extend today's class till 10 o'clock in the night. And in just one class, we can finish a lot of our portions. You tell me what to do. There is a deadlock. To resolve this deadlock, I basically say, let's have both the batches together. And you decide by majority whether we will have an extra class on Saturday or Sunday or not. You decide by majority. But do you know what happens in this case? Batch 1 has an upper hand. Why? Because their number is higher. Their number is 300. Here the number is 100. That means if the decision is to be taken by the majority, what I need? 201 people support. And this 201 people I can get only from batch 1. That means batch 2's, their idea, their objections don't matter because it is the will of batch 1 which prevails when there is this joint session. Similarly, it happens in parliament as well. When one house passes a bill, other house does not agree with that bill, there is a deadlock. And to resolve that deadlock, we have a joint sitting of the two houses. But in the joint sitting of the two houses, which house has the upper hand? Lok Sabha. Why? Because Lok Sabha has 543 members. Rajya Sabha has only 245. It is the will of the Lok Sabha which prevails in a joint session. But constitutional amendment bill is very important. We can't leave it to only one house. That is why Constitution says this constitutional amendment bill, which can be introduced by a minister or by a private member in Lok Sabha or Rajya Sabha without any need for the prior consent of the President of India, this should be passed. This bill should be passed by both houses of the parliament separately. And even if there is a deadlock, there can't be a joint sitting. This bill must be passed by both houses of the parliament separately, only then it can become a law. If there is a deadlock, there is no such thing as joint sitting when it comes to a constitutional amendment bill. But further, let's say this constitutional amendment bill is passed by both houses of the parliament. Then it is sent to the President of India. For what? For signature. Why? Because a bill should be passed by Parliament. Parliament includes President, Lok Sabha, Rajya Sabha. That means Rajya Sabha, Lok Sabha, President, they are integral part of the Parliament. And a bill should be passed by the Parliament. That means by both houses and by the President as well. President, once he signs that bill, this bill becomes a law. But I told you that we will discuss today or tomorrow that President has got some veto powers. President may say, I'm not going to sign this bill. But when it comes to a constitutional amendment bill, President has no option whatsoever. When a constitutional amendment bill is passed by both houses of the parliament separately by special majority, this bill is sent to the President. President looks at this bill saying, oh, this is a constitutional amendment bill. I can't do anything. Where is my pen? Where is my pen? I just need to sign it. That's the only role of the President. But sometimes this bill, a constitutional amendment bill, it may want to amend federal features of the Constitution. And when this bill, which tries to amend the Constitution, it's a constitutional amendment bill, when it tries to amend federal features of the Constitution, this bill, before it can be sent to the President, has to be sent to all the state legislatures concerned. When we say all the states, it includes legislative assemblies of Delhi and Puducherry, because these are the only two union territories right now which have a legislative assembly as well. So this bill, which tries to amend some federal features of the Constitution, if it is passed by both houses of the parliament, before it can be sent to the President, it has to be sent to all the state legislatures, including the legislatures of Delhi and Puducherry. And only when half of the states, their legislatures pass a resolution that yes, we have no problem with this constitutional amendment, only then this bill can be sent to President for signature. President will sign, bill becomes an act. And this state legislature should ratify this constitutional amendment bill by passing a resolution with simple majority. That means when you amend the Constitution, to amend the Constitution, both houses of the parliament require special majority. But if parliament wants to amend federal features of the Constitution, and I'll tell you which are these federal features, then once both houses of the parliament passes a bill by special majority, you send this bill for ratification to all the states in India. And they have to agree. At least half of the states have to agree. That means if we have 28 states, we have 2 union territories with legislative assembly, which means total 30, which means at least 15 of these legislatures should agree that yes, we have no problem with this constitutional amendment. And when they say that they have no problem with this constitutional amendment, they have to say this by passing a resolution by simple majority, not special majority. Parliament will pass by special majority, state legislatures would pass by simple majority. And once it is passed by both houses of the parliament, in case some federal features are amended, ratified by all the states as well, half of the states as well, then it is sent to the President. And President has no other option but to give his assent. Before 1971, he had the power. He could have used his veto as well. He may not have even signed this bill. But after 1971, he has no power. And once he gives his assent, the bill becomes an act. This is how the Constitution is amended. But then we say, and listen to me carefully, your book Lakshmikant is wrong. Wrong in the sense, your book Lakshmikant says that Parliament can amend the Constitution in 3 ways. By simple majority, by special majority, by ratification by at least half of the states. These are the three ways in which Parliament can amend the Constitution. The real picture is, the correct legal position is, Constitution cannot be amended by simple majority. Never. Constitution can be amended only by special majority. But when we say Constitution cannot be amended by simple majority, Constitution can be amended only by special majority, Parliament can still make changes to the Constitution. And those changes shall not be deemed as the amendment to the Constitution. Dikshit is asking, dear sir, kindly once more half of the states, 28 plus 2 is equal to 30 divided by 2 is equal to 15, or more than half state means 16. Constitution says this bill which affects federal features should be ratified by at least half, which means at least 15. If it was more than half, then it is 16 plus. Clear? Constitution can be amended only by special majority. Constitution cannot be amended by simple majority. But Constitution and our Constitution, the beauty of this is that it is flexible as well. That means there are some items in the Constitution, there are some provisions in the Constitution which can be changed, but those changes shall not be deemed as amendment. When these changes shall not be deemed as amendment, that means we don't need special majority, because amendment always requires special majority. That means if these changes are to be made and these changes are not deemed as amendment to the Constitution, which means these changes you can make by simple majority. Simple. Just like I told you when we discussed Article 4 of the Constitution, I told you that when the Parliament is enacting a law under Article 3, there will be changes to Schedule 1 and Schedule 4. But these changes are consequential, incidental in nature. Because when you reorganize the state, obviously you have to add the name of this newly created state in Schedule 1. You also have to provide the representation of the state in Rajya Sabha, which is Schedule 4. So that means these changes are incidental. And when you make these changes shall not be deemed as amendment to the Constitution, which means you don't require special majority. Then what do you need? Simple majority. Basically, you can change these features in the Constitution by passing a law by simple majority. But we say this is not constitutional amendment, because Constitution itself has said that you can change all these things without any need of Article 368, which means you don't need a constitutional amendment bill, which means you don't need special majority. In which are these changes? For example, you form a new state, which will lead to change in Schedule 1 and Schedule 4, but it is not a constitutional amendment. For example, you abolish or create legislative councils. There are 6 states in India right now, which we will discuss later: Andhra Pradesh, Telangana, Maharashtra, Bihar, Uttar Pradesh, Karnataka. These are the only 6 states in India where we have legislative council as well. That means legislative assembly and legislative council. Who can create a legislative council? Parliament. Who can abolish a legislative council? Parliament. And when the state creates or abolishes a legislative council, this law can be passed by simple majority. Although it is a change in the Constitution, because now the Constitution will also say that there are these legislative councils, but these changes shall not be deemed as amendment. Similarly, Constitution said originally in 1950 that the Supreme Court of India shall consist of Chief Justice of India and 7 other judges. That means we will have Chief Justice of India and 7 other judges. These other judges are known as puisne judges. We will have Chief Justice of India and 7 other judges in the Supreme Court. Where is it mentioned? Article 124. It's mentioned in the Constitution. But who can increase the number of judges? Parliament. And when Parliament decides to increase the number of judges, this increase shall not be deemed as amendment to the Constitution. Which means you can make these changes by simple majority. And right now we have a Chief Justice of India and 33 other judges. Although this is also mentioned in the Constitution, that we will have a Chief Justice of India and 33 other judges. But while making this change, you don't have to use Article 368, which means you don't have to use special majority. You can use simple majority, because Constitution itself says that there are some provisions, there are some features of me which you can flexibly change. So I'm giving you flexibility. Change these things by simple majority. But don't call them amendment, because amendment is done by special majority. Amendment is done through the route of Article 368. Similarly, Constitution originally said that Hindi will be the official language of the Union. Official language in the sense, when the central government has to communicate with the states, in which language would it communicate? One example is official language, and that official language has to be Hindi according to the Constitution. But Constitution said for 15 years, we will use English as well. Because we have used English previously, now suddenly, outright, in one fell swoop, we can't shift from English to Hindi. It will take some time. And time given is 15 years. Which means from 1950 to 1965, we will use English as well. After that, English will disappear. Only Hindi will be the Union's official language. But Constitution has further added that if Parliament wants, it can extend the use of English beyond 15 years. If Parliament wants, it can extend the usage of English even beyond 1965. And for that, what Parliament has to do? It has to pass a law. And that law can be passed by simple majority. You don't have to use Article 368. Similarly, any changes that you make in 5th or 6th schedule, those changes can be made by Parliament by passing a law by simple majority. Although you are making changes to the Constitution by making all these changes, but these changes shall not be deemed as amendment. When these changes shall not be deemed as amendment, that means Article 368 is not required. But then the major bulk of our Constitution can be changed by special majority. Majority of the 2/3 members present and voting. And majority of the total membership of the House. Which means fundamental rights, directive principles of state policy, schedules of the Constitution, parts of the Constitution. Major changes to the Constitution can be made through this route, where you use Article 368 and get the bill passed by both houses of the Parliament by special majority. That is how you can change the majority of the Constitution. But then we have a third kind. If the bill wants to amend federal features of the Constitution, then this bill, apart from being passed by Parliament by special majority, should be ratified by at least 1/2 of the state legislatures. That is what we call constitutional amendment of federal features plus ratification by the states. And which are those federal features which require ratification by half of the states? The election and manner of the election of the president, which we will discuss today, how the president is elected. If you want to change the manner of election of the president, For that, you need a constitutional amendment bill, but this bill should be ratified by half of the states as well. Why? Because president is the head of the state. President is the constitutional head. President is elected by states as well. What if tomorrow you decide to pass a bill saying from now onwards only Lok Sabha and Rajya Sabha would elect the president, not the state legislatures? It would be a constitutional amendment. It would be violation of the federal feature, or it will be touching the federal feature where states are involved. Without their consent, you cannot do this. The extent of the executive power of the union and a state. Karnataka government, Chief Minister Siddaramaiah, his power extends throughout Karnataka. Any decision he takes will be applicable throughout Karnataka. What if tomorrow Parliament passes a law and says the power of the Karnataka government extends to the whole of Karnataka except the Bengaluru city? Which means you want to restrict the power of the Karnataka state to rest of the country, Karnataka government to the rest of the state, but not in Bengaluru, in the city. You can't do that without taking consent of all the states. Because what can happen to Bengaluru today can happen to Patna tomorrow, can happen to Chennai tomorrow, can happen to Hyderabad tomorrow, can happen to Lucknow as well. Similarly, provisions dealing with the Supreme Court and High Courts. When NJAC was passed, National Judicial Appointments Commission, what NJAC did, it basically wanted to reimagine the way judges are appointed by the government. And this NJAC was passed by both houses of the parliament by special majority and then sent to state legislatures for ratification. When at least half of the states accepted this, ratified this by passing a resolution by simple majority, it went to the president. President gave his assent, and NJAC became a law. Because any bill which affects the provisions related to Supreme Court and High Court, High Courts are present in the state. Supreme Court can file a case against the center in the state, can file a case against the center in the Supreme Court. So it's a federal feature. If such a feature is to be altered, you need ratification by at least half of the states. Distribution of legislative powers between union and states. We have union list, we have state list, we have concurrent list. And in state list, we have law and order. What if from state list, we take it to concurrent list? Or from state list, we take it to union list? What if citizenship, which is part of the union list, we take it from the union list and drop it in the concurrent list or drop it in the state list? This would be changing the distribution of the legislative subjects between the union and the states. Such a thing can happen, but for that you need ratification by half of the states. For example, GST, goods and services tax. For example, previously VAT was imposed by the state. Now you wanted center to be given the power to impose VAT. Similarly, service tax was imposed by the center. Now you want to give this power to the state as well. You can also impose a service tax. That means you are changing the legislative subjects. For that, you need ratification by half of the states. Representation of states in parliament. Why do you think when women's reservation bill was passed by the parliament recently, 106th Constitutional Amendment Act, which says that 1/3 of the seats should be reserved for women, including in the legislative assemblies. So when state assemblies are involved, why do you think this bill did not require ratification by half of the states? Can state list may also be altered by constitutional amendment? Yes, there have been instances where some items from the state list were taken to concurrent list. For example, education was taken from state list to concurrent list. So if a question comes, can constitution be amended by simple majority? What's the answer? The answer is no. Executive, state machinery. Why state who is not a minister becomes a private member? Schedule 4 of the Constitution. From UP, we will still have 31 MPs in Rajya Sabha. From Telangana, we will still have 11 MPs in Rajya Sabha. Tamil Nadu, Andhra Pradesh 11, Telangana 7, Tamil Nadu 19. We will still have the same representation of states in Rajya Sabha. Since the composition of the states in Rajya Sabha has not been changed, that is why this bill did not require ratification. It is only when you alter the representation of the states in Rajya Sabha, that bill requires ratification by half of the states. And what if you want to change Article 368 itself? You want to change the definition of Article 368 itself. That also requires ratification by half of the states. And what D. Oliver and C. Fusaro has spoken about Indian Constitution. They write a book called How Constitutions Change, which is a comparative study. They basically look at various constitutions of the world and compare them. What is the process of amendment? Is it difficult? Is it easy? What sort of process is followed? And D. Oliver and C. Fusaro say, India's constitution is probably the most sophisticated one in establishing a great variety of procedures to adapt and change its arrangement based upon careful selection of different matters. And the term used for that is flexible rigidity. It is flexible yet rigid. If there are some federal features to be amended, the process is rigid, very difficult. If there are some normal features to be changed in the constitution, for that we can do it by simple majority and we will not even call it amendment. But the matters are carefully selected. Something which affects federal features require ratification by states as well. Something which can be done, which does not have a big ramification, can be done, can be changed, can be altered by simple majority. And Supreme Court has spoken of a list, one by one, of what constitutes basic structure. And this is that list. Supremacy of the Constitution is part of the basic structure. Rule of law is part of the basic structure. Objectives mentioned in the preamble are part of the basic structure. Balance between fundamental rights and directive principles is part of the basic structure. Parliamentary form of government, which basically means if tomorrow Parliament wants to amend the Constitution and say, instead of parliamentary, we will adopt presidential form of government. That cannot happen because parliamentary form of government is part of the basic structure. Free and fair elections is part of the basic structure. Power of the parliament to amend the constitution is also part of the basic structure, but judicial review is also part of the basic structure. Primacy of Chief Justice of India in judicial appointments is also part of the basic structure of the constitution. All these are part of the basic structure of the constitution, which completes our discussion on the doctrine of basic structure and the amendment of the constitution. Whatever questions you have, please tell me. Then we will meet and discuss after the break Union Executive. It may have a legislative assembly when elections are held. Right now it doesn't, so we will not include it. Right by 86th Constitutional Amendment Act. The horrible nexus of bureaucrats, politicians, and business. Nexus how? I need a contract. Let's say mining contract. I pay bureaucrats, they give me this contract. Or what if there is a ban on mining? I will pay money to politicians. They will get a bill passed in the parliament, open up mining as well. So this nexus for each other's benefit is what we call crony capitalism. And what does this businessman get? Profit. And what does the politician and the bureaucrat get? Money. Politician gets money to fund his election. Bureaucrat gets his money to live a lavish life. Sir, who defines the components of basic structure of the Constitution? Supreme Court. How to remember union list, state list, concurrent list? You don't need to remember. Do we have to learn all articles? No. It's the power of the court to accept public interest litigations. Parliamentary form of government is one in which Council of Ministers are accountable to Lok Sabha, or Council of Ministers are accountable to the lower house of the Parliament. is Ram and who is Sita. Basic structure doctrine is a judicial innovation. It's not mentioned anywhere in the Constitution. That means it is not mentioned in the Constitution. It is the judicial innovation. Judiciary decides that this is part of the basic structure. But where is it mentioned? It is mentioned in the judgments. It is not that once the Supreme Court says rule of law is part of the basic structure, then we will add an item in the Constitution and say this is basic structure chapter, rule of law is added. It is not like that. Ratification for Women's Reservation Bill was not required because it does not alter the representation of states in the Rajya Sabha. If it would have altered the representation of states in Rajya Sabha, it would have required ratification. Do you know who asked this question? Musharraf. Musharraf also, in a coup, took over the powers of the government and removed Nawaz Sharif from the prime ministership. Can such a thing happen in India? No. Because the countries are wired differently. The philosophy of the two countries is different. Throughout its existence, Pakistan has been controlled by military generals. Whether it is Ayub Khan, whether it is Yahya Khan, whether it is Ziaul Haq, whether it is Pervez Musharraf, they have been ruled for most of their parts, most of their existence by the military generals. Such a thing cannot happen in India. You have not received a single reply. I'm sorry for that, but you can ask me what your question is. In 9th schedule till 24th April 1971, there won't be judicial review. But basic structure doctrine was created, innovated on 24th April. Basic structure includes judicial review. So any law placed in 9th schedule after 24th April 1971, there will be judicial review. Okay, you can mention your question. I'll come back from break. Indian polity, separation of powers, doctrine of checks and balances, constitutionalism. We discuss what is a unitary and federal constitution, then preamble, union and its territory, citizenship, fundamental rights, directive principles of state policy, fundamental duties, the doctrine of basic structure, and how constitution can be amended by the parliament using Article 368. This covers a significant chunk of our syllabus. Now let's come to the other part where we will talk about union executive. And in union executive, we will have to discuss the offices of the president, vice president, prime minister, council of ministers, and the attorney general for India. So if tomorrow there is a question, who all are part of the union executive, you should know president, prime minister, vice president, council of ministers, and attorney general for India. All these are part of the union executive, and we will have to discuss all these institutions one by one. Beginning with the office of the President of India. How is the president elected? What are the qualifications in order to become the President of India? How is the president impeached, basically removed from his office? What are the powers and functions of the office of the President of India? All this and much more. So let's start this fascinating journey and understand the President of India. Constitution says under Article 52, which is the shortest article in the Constitution, that there shall be a President of India. This word shall means that the office of president can never remain vacant. There has to be the President of India at all times. Our system, our political system, cannot be envisaged to continue even for a moment without somebody occupying the post, the position of the President of India. There has to be a President of India. There shall be a President of India. There has to be a President of India at all times. We can't function without the President. And the very next article, Article 53 says, the executive power of the Union shall be vested in the President. One, Article 52 shortest article in the Constitution, which says there shall be a President of India. That means we can't imagine somebody not holding the office of the president. There has to be a president. And all the executive powers are vested in the name of the President of India. Reading Article 52 and 53 together, we see, or we can assume, that the office of president is very important. Because on one hand, we can't function without president. And on the other hand, all the executive powers are vested in the name of the President of India. But this is where the problem lies. Problem number one is that this term, what is an executive power, is not defined in the Constitution. So what is this executive power which is vested in the name of the President of India? We would not know because it has not been defined clearly in the Constitution. Then what do? We either look at judicial judgments, what judiciary has said, because final interpreter of the Constitution is the judiciary, or we look at what some constitutional experts are saying about what is this executive power which is given to the president. 1955, Ram Jayawa Kapoor versus State of Punjab, 1955. Supreme Court said this executive function comprises both the determination of policy as well as carrying out its execution. So what should be our policy vis-a-vis Pakistan, for example? Let's withdraw the High Commissioner from Pakistan. That's the executive decision taken by the president. What should be our policy vis-a-vis what should be our policy vis-a-vis backward sections of the society? We should provide them a right to work. MG Narega, National Rural Employment Guarantee Act. That's a policy decision taken in the name of the president, done by the president. It includes initiating a legislation. Initiation of legislation means we want to provide 10% reservation to economically weaker sections of the society. For that, we have to initiate a law, initiate a bill. That's the power of the president. We have to maintain law and order in the society, ensure that China is defeated, Pakistan is defeated. That is also the power available with the president. We have to promote social and economic welfare, ensure that untouchability is eradicated. For that, we need a law. And how do we implement this law? That is also the power of the president. What should be the direction of our foreign policy? What should be our decision vis-a-vis Israel-Palestine conflict? That's the executive power. That's vested with the president. What should be our position on the Russia-Ukraine conflict? That's our foreign policy. That is the power available with the president. That means Supreme Court said in Ram Javaya Kapoor versus State of Punjab, defining what is this executive power, and all this executive power is vested in the name of the President of India. But sir, it is still not clear. Then we look at what Wade and Bradley, constitutional experts, they write in Constitution and Administrative Law. They say, what is this executive function? It's like a residue. It's like a leftover. When you exclude legislative and judicial powers, whatever else is left, that's the executive power. And all this executive power is with the president. For example, the process of photosynthesis. What is the ultimate objective of photosynthesis? Green leaves should manufacture their own food. C6H12O6. C6H12O6. Is that the formula for glucose? But then oxygen is also released in the atmosphere. That means carbon dioxide plus water in presence of catalyst, which is sunlight. Then there are some green pigments, chlorophyll, so on and so forth. It manufactures, this process of photosynthesis manufactures food for the green plants, but at the same time it releases oxygen in the atmosphere. That oxygen is a byproduct. That means that is not the aim. This process of photosynthesis aim is not to release oxygen. The objective is to produce food. Byproduct is the oxygen release. That means oxygen is the residue left over. Similarly, when we look at all the powers, and if we exclude legislative powers, if we exclude judicial powers, whatever else is left, that's the executive power, because that's the residue. And that executive power is vested in the name of the President of India. Looking at both Article 52 and 53, you might get a sense, maybe a misplaced sense, an incorrect sense that President is all powerful. But you don't have to look at Article 52 and 53 in isolation. You have to look at Article 52 and 53 together with Article 74 of the Constitution. And Article 74 says, there shall be a Council of Ministers with Prime Minister at its head. To do what? To aid and advise the President. This is how Article 74 looked like when the Constitution was enacted. Union Executive includes President, Vice President, Prime Minister, Council of Ministers, Attorney General for India. Let's look at all these institutions one by one, beginning with President. Article 52, there shall be a President of India. That means we can't function even for a brief moment without somebody occupying the post of the President. And Article 53 says all executive powers are given to this President, are vested in the name of the President, are taken in the name of the President. So you might get a sense that President is all powerful in India. But that would be the incorrect reading of Article 52 and 53. Because Article 52 and 53 are to be read with Article 74, which says there shall be Council of Ministers with Prime Minister at its head to aid and advise the President. So how President will use his executive power, that will be decided by Prime Minister and his Council of Ministers. So all these executive powers, whether it is initiating a legislation, that will be advised to the President by the Prime Minister and his Council of Ministers. How to carry out foreign policy, that will be advised to the President by Prime Minister and his Council of Ministers. How do you maintain order in the society? How do you plan social and economic policies? That will be advised by the Council of Ministers and the Prime Minister to the President of India. But nowhere in the Constitution was it mentioned that this aid and advice is binding on the President. Is it mentioned in the Constitution under Article 74 that whatever advice is given by Chief Prime Minister and his Council of Ministers is binding on the President? No. When the Constituent Assembly met to discuss, decide the kind of polity that we want to create in India, they agreed with that we should have a parliamentary form of government. Just like we have this parliamentary form of government in UK, we could have experimented with a lot of other functions. We could have experimented with a lot of other options that were available. We could have opted for a presidential form of democracy. Just like we have in United States of America, where president is all powerful. There is nobody to advise Joe Biden that you should go to Israel or you should not go to Israel. There is nobody to advise Joe Biden that you should not, or you should say that this hospital in Gaza was bombed by Israel or not bombed by Israel, or bombed by Hamas or not bombed by Hamas. There's nobody to advise the president. He has all the powers. We could have opted for that presidential form of democracy in India where president is all powerful. But we did not. And instead we chose the British model of a parliamentary democracy. Why? Reason number one is because this form was practiced in India. We saw from very close quarters how this parliamentary form of government functions. How? Because in Britain, although they have a queen, although they have a king, they have a monarch, but the real power is with the prime minister and his council of ministers. Whatever they advise the queen, she has to do this. Whatever they advise the king, they have to do this. And this prime minister and council of ministers, they are elected directly by the people. If we have a presidential form of democracy, then we may not be able to represent the diversity that we have. Today, if you look at Prime Minister and his Council of Ministers, a minister is from Gujarat, a minister is from Punjab as well, a minister is from Haryana as well, a minister is from UP as well, representing the different geographies that we have. A minister can be a scheduled caste, a minister is also an OBC, a minister is also a tribal, a minister is also a Sikh, a minister is also a Christian, not a Muslim minister now, but representing the diversity that we have. That means parliamentary form of democracy, it has the power, it has the option of representing various diverse groups that we have in India. Different regions, different castes, different religions, different tribes. So you give representation to every section of the society, representing the diversity that we have. But if it was only the president of India, the president may have been from an upper caste, and whatever decision he takes would be binding on everybody. So there will be lack of diversity representation if it was a presidential form of government. But presidential form of government is also quick to take a decision, faster decisions. Joe Biden decides to take Air Force One, a plane, and go to Israel. I've taken the decision. But in a parliamentary form of democracy, Prime Minister cannot take his own decision. He has to involve all the cabinet ministers, representing the different diversity, saying we have to take this decision. Let's do this, let's do that. Do we have a consensus? So basically, it may lead to a delayed decision. But in a presidential form of democracy, quick decisions are taken. But quick decisions may not always be good decisions. These can be hasty decisions as well. But collective decisions may always be good decisions. May. So we opted for this parliamentary form of democracy in the Constituent Assembly, which met for the first time on 9th of December 1946. They decided to give India its constitution. Who was the president of this Constituent Assembly? Dr. Rajendra Prasad. Dr. Rajendra Prasad later on became the first president of independent India. And when the constitution was being debated inside the Constituent Assembly, the members of the Constituent Assembly said and envisaged and imagined an India of parliamentary democracy, where the real power is with the Prime Minister and his Council of Ministers, because they are directly appointed by the people, elected by the people. And Dr. Rajendra Prasad said, when we say there shall be a president of India, when we say all executive powers are vested in the name of the president of India, that does not mean president has discretion. That does not mean president can take decisions on his own. President has to abide by whatever aid and advice is given by the Prime Minister and his Council of Ministers. So the real power is with the Prime Minister and his Council of Ministers, directly elected by the people. And whatever advice they give to the president, that's binding on the president. Who said this? Dr. Rajendra Prasad. Who was he? The president of the Constituent Assembly. Later on, who did he become? He became the first president of independent India. And when he became the president of India, he went to a Calcutta University, a law college in Calcutta, and there he gave a speech. He said, don't consider the president of India so weak, so powerless. Because on one hand, we have Article 52, which says there shall be a president of India. This term is not mentioned for the Prime Minister. That means president is powerful. 53 says all the executive powers are vested in my name. And even if you read it with Article 74, it does not say that this aid and advice minister and council of ministers is binding on me. Because it only says there shall be council of ministers with prime minister at its head to aid and advise the president. Whether the president is going to accept that advice or not, that is left to the discretion of the president. That president has to decide. In fact, Somnath temple was to be reconstructed. It was reconstructed and then it was to be thrown open to the public. Dr. Rajendra Prasad, as the president said, I'm going to visit Somnath temple to open it. Pandit Nehru advised him, don't go. Why? Doesn't look nice. Why? You are head of the republic. You are head of the state. And as the head of the state, you should not identify yourself with a particular religion because we are secular. As the president of India, if you open a Hindu religious temple, it may give a sense that we are a Hindu Rashtra. Don't do this. Rajendra Prasad said, no, I will go. And going against the advice of the Prime Minister, he went and inaugurated the Somnath temple in Gujarat. And basically saying, nowhere is it mentioned that this aid and advice is binding on me. Matter went to the court. Not on this matter, there was a different matter as to whether governor has the power or president has the power, or they have to exercise all their powers only on the advice of the chief minister, only on the advice of the prime minister. Ram Jayawal Kapoor said, president is only a formal head, only a constitutional head. The real power is vested in the hands of the ministers, is vested in the name of Council of Ministers. Council of Ministers is the chief minister at the state level, Council of Ministers and the Prime Minister at the central level. So president is only a nominal head, just like the Queen and King of England. The real power is with the ministers. Because we follow a parliamentary form of democracy, not the presidential form of democracy. Matter went to the court again. UNR Rao versus Indira Gandhi, 1971. Again, Supreme Court, please, you are the final interpreter of the Constitution. Please tell us, what is the role of the president? What is the power of the president? Does he or she have more powers as against the Prime Minister? Supreme Court said the same thing. Our Constitution is modeled on the British parliamentary system, where Prime Minister and his Council of Ministers, they are the real power holders. They have to exercise all these executive powers. President is only a nominal constitutional head. Matter went to the court again. Shamsher Singh versus State of Punjab. The question was that there was an individual who had committed some crime and he was to be released. The governor decided, I will release this individual. Council of Ministers were not in agreement. They did not want that person to be released. There was also another matter where judges were to be appointed to a tribunal. Or there was a matter where a judge was to be removed. A district judge was to be removed. And the governor removed that judge, going against the advice of the Council of Ministers. Matter went to the court. The court was asked that there is something known as satisfaction. If the president is satisfied, he can promulgate national emergency. If the president is satisfied, he can impose president's rule. If the president is satisfied, he can impose financial emergency. If the president is satisfied, he can promulgate an ordinance. If the governor is satisfied, he can remove a judge. Is this personal satisfaction of the president or the governor? Or is it the satisfaction of the Council of Ministers headed by the Prime Minister? The court said in Shamsher Singh case, it is not the personal satisfaction of the president or the governor. It's not that the president should be personally satisfied, then he can impose emergency. It is basically the satisfaction of the Prime Minister and his Council of Ministers. Once they are satisfied, they can advise the president, impose financial emergency. Once they are satisfied, they can advise the president, impose president's rule. Once they are satisfied, they can advise the president, please promulgate an ordinance. It is not the personal satisfaction of the prime minister and his council of ministers. This was 1974. Which means if the constitution says there shall be a president of India, and Article 53 says all the executive powers are vested in the name of the president, does that mean president is so powerful? Because Article 74 also is slightly silent. It says there shall be council of ministers with prime minister at its head to aid and advise the president. Where is it mentioned that this aid is binding on the president? Nowhere. But then we went to judiciary. Whether it was Ram Jayawar Kapoor, whether it was the Shamshed Singh case, whether it was UNR Rao versus Indira Gandhi case, Supreme Court has categorically stated that we follow a British parliamentary model, where every advice of the Prime Minister and his Council of Ministers is binding on the President of India. President does not have the discretion. What is discretion? President doing something on his own, without the aid and advice of the President. There is no such thing as discretionary power available with the President. But perhaps all these things may have been communicated by Pandit Nehru to his daughter, Indira Gandhi, that tomorrow, whenever you become the Prime Minister, if at all, you should take a look at Article 74. Because Article 74 says there shall be Council of Ministers with Prime Minister at its head to aid and advise the President, full stop. It does not say that this advice is binding on the President. Just keep that in mind, then you can become a good Prime Minister. And maybe Indira Gandhi realized this. And when Indira Gandhi realized this, Constitution was amended. 42nd Constitutional Amendment Act, 1976. Article 74 was amended. Article 74 then said, there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President. Then this term was added, this phrase was added, who shall in the exercise of his functions act in accordance with such advice. This was added by 42nd Constitutional Amendment Act, 1976. Now the Constitution is saying categorically, whatever advice is given by Prime Minister and his Council of Ministers to the President, that is binding on the President. President, get up, sit down, binding. This was 1976 when emergency was in place. 1977, emergency was revoked and fresh elections were called. All the opposition or most of the opposition political parties, they decided to come together and fight against Indira Gandhi. And they had a promise for the people of India. The promise was, we will undo all the changes that Indira Gandhi made to the constitution when we will come to power. President's eyes also lit up. Really? Are you also saying that whatever changes were made to my office, you will undo all those changes? I will pray to God that you become the Prime Minister, your party comes to power. And in 1977, Janata Party came to power, Morarji Desai became the Prime Minister, and Article 74 was amended again. This paragraph was added by 44th Constitutional Amendment Act, 1978. Provided that the President may require Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice retendered after such reconsideration. Which means originally Constitution said there shall be Council of Ministers with Prime Minister at its head to aid and advise the President. 1976, who shall act according to that advice? That means it is binding for the President to accept that advice. He can't do anything else. Janata Party came to power, amended Article 74 again, saying President may ask for reconsideration of that advice. But once the advice comes again, it is binding on the President to accept that advice. Which means if we were to look at this Article 74 till 1976, if Prime Minister would have advised the President impose national emergency. President may not have accepted this advice, saying, no, I will not impose this. No, you have to impose this. This is my advice. Where is it mentioned that your advice is binding on me? I will not accept your advice. I'm not going to impose national emergency. But because of 42nd Amendment, now if the Prime Minister advises the President, impose national emergency, yes, madam, whatever you say, I have to abide by that. But after 1978, if the Prime Minister advises the President, impose national emergency, President will say, can you please reconsider? Maybe we should not impose national emergency. These are the reasons I think we should not impose national emergency. Please reconsider your advice. But if the Prime Minister says again, no, impose national emergency, President will say, okay, because now that you have reconsidered your advice and you have advised me again that impose national emergency, I bow down before you, national emergency is imposed. Which means President felt cheated. Cheated in the sense, I thought you will undo the changes that Indira Gandhi made to the constitution. You will restore my powers back to you. Now you have not done anything. Indira Gandhi would have said, get up, I had to get up. Sit down, I had to sit down. Now the only change is, if you tell me get up, I will say, can I please sit? Now get up, I have to get up. If you say sit down, I can only say, can you please go back on your advice and advise me that I should remain standing? No, sit down, I have to sit down. That means nothing changes. It's only that President will only once ask for reconsideration. Can we not impose national emergency? Can we not promulgate ordinance? Can we not impose President's rule? Can I not appoint that individual? But if the advice is given again, President is bound by that advice. So what is the constitutional status of the President of India? We say that there are no discretionary powers available with the President. That means President cannot do anything of her own. This President always shall act on the advice of Prime Minister and his Council of Ministers. Which basically means President is a rubber stamp. Whatever is communicated to the President by the Prime Minister and his Council of Ministers, the President shall have to do that. That is the constitutional position of the President of India. But President is head of the state. We say President is the first citizen of India. Which means whenever census exercise would be carried out, the first person to be enumerated in the census would be the President of India, followed by the spouse of the President of India. But this is the constitutional position of the President of India. Any questions? And whatever questions you have, we will discuss all of them one by one. But first, let's complete this. Because I can see some of the questions. Sir, can President use veto? How President appoints Prime Minister? We will cross the bridge once we reach there. One by one, all your doubts would be clear. But how is the President of India elected? We say President of India is elected by the Electoral College in an indirect election through a system of proportional representation system by means of single transferable vote through secret ballot. This is how the President is elected. Is that clear? It won't be clear. We will explain all these things one by one. What is this Electoral College? You are from Varanasi, Lok Sabha constituency. And the people of Varanasi will have to vote to elect one representative, which is Mr. Modi right now. But who is the Electoral College of Varanasi? Which means who gets to vote to elect representative of Varanasi in Lok Sabha? All the people in Varanasi who are above the age of 18, those who have the right to vote. That means all the people in Varanasi who are above the age of 18, whose names are mentioned in the electoral rolls, they are part of the electoral college to elect their representative to Lok Sabha. Similarly, who is part of the electoral college who can vote to elect the President of India? That electoral college consists of elected members of both houses of the parliament. Which are the both houses of the parliament? One we have Lok Sabha, the other we have Rajya Sabha. In Rajya Sabha, we have elected members as well. We have nominated members as well. Next week, when we will discuss parliament, we will discuss what is the composition of Rajya Sabha. There I will tell you that some members of Rajya Sabha are elected and some members are nominated. Who nominates these MPs of Rajya Sabha? President. From the field of art, literature, science, social service. For example, President has nominated Sachin Tendulkar to Rajya Sabha, Rekha to Rajya Sabha, Justice Ranjan Gogoi to Rajya Sabha, Mary Kom to Rajya Sabha. All these are nominated members of Rajya Sabha. They are not elected. They are nominated by the President to Rajya Sabha because they have done something well in the field of art, literature, science, social service. And these nominated members, they are not part of the electoral college. That means tomorrow if the President is to be elected, these nominated members of Rajya Sabha will not vote to elect the President of India because they are not part of the electoral college, because they are nominated. Similarly, in Lok Sabha, we used to have 2 nominated MPs in Lok Sabha. And we will discuss it in Lok Sabha. Who were these 2 nominated MPs? Basically, in Lok Sabha, we used to have 2 Anglo-Indians who were also nominated to Lok Sabha. But now, because of a constitutional amendment, 2 Anglo-Indians, their reservation in Lok Sabha is gone. Why this happened, we will discuss that in Parliament. But even these 2 nominated Anglo-Indians were not part of the electoral college. Why? Because they were nominated, they were not elected. Only those MPs of Parliament, both houses of the Parliament, both Lok Sabha as well as Rajya Sabha, who are elected, only those are part of the electoral college to vote to elect the President of India. Electoral college also consists of elected members of the legislative assemblies of states. There are some states where we have legislative council. Legislative council members are not part of the electoral college. Legislative assembly members are part of the electoral college. But only those legislative assembly members who are elected by the people. Because in state legislative assemblies also, there used to be 1 nominated Anglo-Indian. Anglo-Indians basically, they were British citizens. They stayed in India. Once the country became independent, they decided not to go back to Britain. They decided to stay in India. Those are Anglo-Indians. That means Indians, but their ancestry is English. You would have read in your modern history, Anglo-Maratha wars. That means war between Marathas and English. Anglo, related to England. Ancestry is English, but they decided to stay put in India, not go back to Britain. These are Anglo-Indians. And 1 Anglo-Indian used to be nominated to Legislative Assembly. But Electoral College consists of elected members of both Lok Sabha as well as Rajya Sabha, elected members of the assemblies of the states, not council of the state, only assemblies. And states include UTs of Delhi and Puducherry. Since these are the 2 union territories where we have legislative assembly, the elected MLAs of Delhi Assembly, the elected MLAs of Puducherry Assembly, they are also part of the electoral college to elect the President of India. That means the president is elected by electoral college. Who are the members of the electoral college? Elected members of Lok Sabha and Rajya Sabha, elected members of the state legislative assemblies, elected members of the legislative assemblies of Delhi and Puducherry. All these are part of the electoral college. All these have the voting rights to elect the president of India. Sir, but what about UT of Jammu and Kashmir? This is where we have two viewpoints. Viewpoint 1, viewpoint 2. When President Draupadi Murmu was to be elected, Jammu and Kashmir Legislative Assembly MLAs could not vote. Why? Because there was no legislative assembly in Jammu and Kashmir. But even if there was a legislative assembly in the UT of Jammu and Kashmir, could they have voted or not? For that, we have two viewpoints. One viewpoint says, yes, they would have voted. Second viewpoint is, no, they would not have voted. Viewpoint number 1, which says, yes, whenever elections take place in Jammu and Kashmir Union Territory, whenever members are elected to the Legislative Assembly of Jammu and Kashmir, automatically they will become part of the electoral college. Why? Because the Jammu and Kashmir Reorganization Act, it says whatever is true for Puducherry, that is true for Jammu and Kashmir. That means Jammu and Kashmir Union Territory was created on the model of Puducherry. Whatever is true for Puducherry will be true for Jammu and Kashmir. And are the MLAs of Puducherry part of the electoral college to elect the President of India? Yes. That means by the same logic, Jammu and Kashmir Legislative Assembly, once it is elected, their MLAs will also be part of the electoral college to elect the President of India. But there is another viewpoint which says no, it cannot happen. Why? Because for that you need a constitutional amendment. And not a normal constitutional amendment. Constitutional amendment along with ratification by half of the states. Why? Because when we discussed amendment to the Constitution, in amendment to the Constitution, I told you that there are some federal features if the Parliament wants to amend. Those federal features, if the Parliament wants to amend, it requires constitutional amendment bill, it requires ratification by at least half of the states as well. One such federal feature is if you want to change the election and manner of election of the president. Which means the Constitution said electoral college to elect the President of India shall consist of elected members of both houses of the Parliament, elected members of the legislative assemblies of states. So if Jammu and Kashmir was a state, it is part of the electoral college automatically. If tomorrow Jammu and Kashmir is given statehood back, their MLAs will automatically become part of the electoral college because every elected MLA of the legislative assembly of a state is part of the electoral college. But if you interpret this term states to also include those union territories with legislative assembly, for that you have to amend the constitution. And that's precisely what was done. When Delhi MLAs, when Puducherry MLAs were also included into the electoral college, it was done by a constitutional amendment and followed by ratification by half of the states. Because whenever you change the manner and method of president's election, you have to get the ratification of the states. So if you change the manner, if you change the electoral college, if you include UTs with legislative assembly as well, you have to amend the constitution. And tomorrow, if your interpretation is that this term state also includes the legislative assembly of the union territory of Jammu and Kashmir, you have to amend the constitution, get the ratification of half of the states, then J&K legislative assembly UTMLAs will be part of the electoral college. But if J&K becomes a state, then all the MLAs of the states automatically are part of the electoral college. That is viewpoint number one, viewpoint number two. But long story short, the president is elected by the electoral college. And who is part of the electoral college? Elected members of Lok Sabha and Rajya Sabha. Elected members of the legislative assemblies of the states. Assemblies, not legislative council. Including the elected MLAs of Delhi and Puducherry Legislative Assembly. What about J&K Assembly? One argument, one viewpoint says, whatever is true for Puducherry is true for J&K. So if Puducherry MLAs are part of the electoral college, J&K MLAs are also part of the electoral college. Viewpoint number two, it says no. When Puducherry MLAs and Delhi MLAs were made part of the electoral college, that was done through a constitutional amendment along with ratification by at least half of the states. Why? Because this is a federal feature. If you change the manner of president's election, you need constitutional amendment act of third kind. And if you want to include J&K MLAs as well, for that you need a constitutional amendment. But sir, tell us which viewpoint is correct. I don't know. Why? Because we still don't have a legislative assembly in Jammu and Kashmir. We didn't have a legislative assembly when President Murmu was elected. So when there is no legislative assembly, which means they are not part of the electoral college. But even if they had a legislative assembly and it was a UT, then we would have got the clearer picture whether they are automatically included or for that we need a constitutional amendment. But this is what an electoral college is. President is elected by the electoral college. But can we say president is elected by the people of India? Can we say the president is elected by the people of India? Yes, no, 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 yes, no, yes, no. President is elected by the people, yes, but not directly, indirectly. Through their representatives. In the electoral college. Who are part of the electoral college? Legislators. These legislators are elected by the people. And these members of the electoral college elect the president of India. That means president is also elected by the people, but not directly. People don't directly vote to elect the president. Indirectly, through their representatives in the electoral college. But now the question should be on your mind, why? Why indirect election? Why not direct election? Why can't we directly vote to elect the president of India? Constituent Assembly debated this. It's not that only we are debating right now. Constituent Assembly also debated this. Because Constitution, after all, was given after a thorough debate. Constituent Assembly, some members said we should have a directly elected president. But then ultimately we favored an indirect election. Why? Number one, if the real power is with Prime Minister and his Council of Ministers, and this Prime Minister and his Council of Ministers are directly elected, Do we directly elect the Prime Minister? No. We elect a Lok Sabha MP. And these Lok Sabha MPs then decide who becomes the Prime Minister. That's the normal procedure. Which means we elected Sunny Deol, we elected Smriti Irani, we elected Amit Shah, we elected other members, we elected Rahul Gandhi as well, although he lost from one seat but won from Wayanad. And now all these 543 MPs in Lok Sabha, whoever has the majority becomes the Prime Minister. Whoever has more than half of the strength of Lok Sabha becomes the Prime Minister. And since BJP got 302 seats out of 543 in 2019 elections, all these MPs, they got together and they decided that let's have Mr. Modi continue as the Prime Minister. So Mr. Modi is not directly elected as the Prime Minister of India by the people, but he is directly elected as the MP. And as MPs, they get to decide who becomes the Prime Minister. Constituent Assembly said if the real power is with the Prime Minister and his Council of Ministers, if Prime Minister is also directly elected, President is also directly elected, it will lead to clash of egos. Prime Minister advises the President, please promulgate an ordinance. Do that. President will say, you can't talk to me like this. Why? I am directly elected by the people, so am I. Clash of egos. That is why we settled for indirect election. Not just this. If the real power is with the Prime Minister, with the Council of Ministers, why waste time and resources? Look at the amount of money that would be spent if all the people of this country above the age of 18 would have to come together to elect the President of India. And then elect the President of India directly, but this President does not have power. Real power is with the Prime Minister and his Council of Ministers. The real power is with Modi ji. So why Ms. Draupadi Murmu be elected directly by the people by spending thousands of crores of rupees? But at the end of the day, she does not have power. That would be wastage of time, that would be wastage of resources if we have direct election to the office of President. Because in any case, the real power is not with the President, but with the Prime Minister and his Council of Ministers. That is why the Constituent Assembly settled for an indirect election. Which means the President of India is elected by the Electoral College. This much is understood. In an indirect election, this much is understood. Through a system of PRS. And what is this PRS? Proportional Representation System. And what is this proportional representation system? Article 55 says, as far as practicable, there shall be uniformity in the scale of representation of different states at the election of the President. And to understand that, first we need to understand what is first past the post system. And it is this first past the post system that we follow for Lok Sabha, that we follow for Legislative Assembly elections. What is this first past the post system? Let's assume that this is a constituency. Because whenever elections are to be conducted in the entire country or in a particular state, the entire country is divided into constituencies. Let's say when 2019 elections was conducted, 543 constituencies were there. From every constituency, one candidate would be elected. Let's assume this is one constituency. And in this particular constituency A, 1 lakh people have voted. whether candidate X, Y, Z, P, Q, R. If X is to be your representative, if X is to be your candidate, if X is to represent your constituency, how many votes out of 1 lakh should X get in order to be elected to Lok Sabha or Legislative Assembly? Amrit says 50,001, Ritika says 50,000 plus, Manisha more than others, higher votes, majority. Not the majority. Highest number of votes. Which means, what if X gets 19,000 votes, Y gets 18,000, 17,000, 5,000, 900, 600, for example. Who is the representative from your constituency? X. X did not get the majority. Majority is 50,000 plus, 50,001 at least. But you don't believe in majority in first past the post system. In first past the post system, you always choose somebody with the highest number of votes. That means, despite the fact that 81% people, 81% voters voted against X, even then X is your representative. Why? Because X got higher votes than others. This is what we call first past the post system. In first past the post system, the entire country is divided into constituencies. You have to elect one member from constituency. Who is this one member going to be? Not somebody who gets the majority of votes necessarily, but somebody who gets the highest number of votes. It may also be possible that this X gets 78,000 votes, which is more than majority. But that is not our intention. Our intention is to pick somebody who has got the highest number of votes, higher than others, not necessarily majority. But it is this first past the post system which throws peculiar challenges as well. For example, in 2014, Lok Sabha elections, which political party got the highest number of votes? The party was BJP. Then it was the Indian National Congress. BJP got close to 32% votes. Congress got close to 19.67% votes. How many seats did BJP win? 282. How many seats did Congress win? Spectacular performance under the dynamic leadership of Shri Rahul Gandhi. They bagged the lowest in its history, 44 seats. Which was the third party with highest number of votes? BSP. Behenji Mayawati's BSP with 4.2% votes. Number of seats, 0. How is that possible? BJP got 32% of the votes. But this 32% votes gave them 282 seats. That means more than half of the seats. Congress got close to 20% votes. But it did not translate into 20% of the seats. They could not even get 10% of the seats. BSP got 4.2% votes throughout the country, but no seat in Lok Sabha. Why? AIADMK, Trinamool Congress, less than 4% seats, 4% votes, but more than 30 seats each. AIADMK close to back 37 seats in Tamil Nadu. 33 or 35 seats to Trinamool Congress, despite the fact that they got less number of votes, lesser than BSP. BSP got 4.2%, 0 seats. AIADMK, Trinamool Congress, less than the votes of the BSP, but more than 30 seats each. How's that possible? BSP's vote share is spread across the country. For example, in UP, for example, Rajasthan, for example, Chhattisgarh, for example, Karnataka. That means it may be possible that there were some seats where BJP emerged winner with 19,000 votes, but the second candidate was BSP with 18,000 votes. In no constituency that BSP contested could they get the highest number of votes. That is why they could not win any seat. But the voters or the support of AIADMK is restricted to Tamil Nadu and Puducherry. Supporters of Trinamool Congress is restricted to West Bengal. There, in all these 30 seats, more than 30 seats, their candidate got the highest number of votes, and they won the election. They won these many seats. But the problem is, this 4.2% people who voted for BSP, they have no representation in Lok Sabha. Their votes are as if these votes have lost their significance, their meaning. This is first past the post system. If it was a proportional representation system, what is a proportional representation system? In proportion to your vote share, those many seats you will get. Which means if 543 seats are there in Lok Sabha, BJP, if it was first past the post system, they got these many seats. But if it was the proportional representation system, 32% of 543 will go to BJP. 19.67 of 543 will go to the Congress. 4.2% of these seats will go to the BSP. That means in proportion to your vote share, those many seats will be allocated to you. That is proportional representation system. But there is a drawback with proportional representation system as well. It may not always lead to stable government. Despite the peak of the Modi wave in 2014, BJP could get only 32% votes. Despite the peak of the Modi wave in 2019, the BJP could get 37% of the votes, which means 63% people still vote against the BJP, which means they would have got less than 50% of the seats in Lok Sabha, which means then again coalition governments, which means BJP will have to form a sarkar known as the Khichdi Sarkar, where various political parties come together to form the government. But that government is not always stable. That government is not always quick in taking decisions. But Constitution envisaged, forget about parties and their vote share. Look at various states. If we were following first past the post system in India for presidential election as well, imagine the situation. How many states do we have? 28. How many UTs do we have with legislative assembly? 2. Total it is 30. Which means if we were following first past the post system for president's election as well, for that number of constituencies would have been 30. Number of constituencies would have been 30, 28 states and 2 union territories with legislative assembly. Let's suppose there are 3 candidates contesting election. Candidate A, B, C. Clear? Candidate A bags 10 seats. Candidate B bags 10 seats. Or let's say candidate A bags 11, candidate B bags 9, candidate candidates B bags 10, candidate C bags 9. Who is the President of India? A, 100%, because first past the post system, you don't have to believe in majority. You have to get the highest number of votes. But imagine this situation. These 11 seats are 7 northeastern states, Sikkim, Goa, Puducherry, and let's say a smaller state, let's say Haryana. With no disrespect to the northeastern states or these states, this is just to give you an example. The population of these 7 northeastern states, barring Assam, is very less. Arunachal Pradesh, Mizoram, Meghalaya, Nagaland, Tripura, Sikkim, Goa, Haryana, these are smaller states and UTs. Majority of the states where we have a higher population are backed by candidate C. Candidate C gets UP, Maharashtra, Madhya Pradesh, Rajasthan, Bihar, Karnataka, Telangana, Tamil Nadu. These 9 states which have a massive population, they support candidate C. Yet who is the winner? Candidate A. But candidate A gets the vote or gets the support of smaller states with smaller population. We cannot envisage a situation where we have the President of India, but who is elected by the minority. Not religious minority, elected by smaller population base. That is why for the president's election, what we do, we follow proportional representation system. And what is this proportional representation system? Based on a state's population, those many votes will be allocated to that state. If UP has a massive population, it will have more votes as compared to Sikkim. That means population would be the criteria to decide how many votes should we give to a particular state. And for that, we have a formula. And at the end of that, when voting takes place, whoever gets majority, which means more than half of votes, what we call valid votes, and I'll tell you what is this valid vote. This person becomes the President of India. President is elected by the Electoral College. This is clear. In an indirect election, this is clear. Through a system of proportional representation system. But to understand proportional representation system, we need to understand first past the post system, which means there will be constituencies. Who will be elected from your constituency? Somebody who gets the highest number of votes. Not somebody necessarily who gets the majority of votes. But in proportional representation system, what is the proportion of your strength? Those many votes will be given to you. That much representation we will give you. For example, if in president's election we would have followed first past the post system, which means the entire country would have been divided into 28 states and 2 union territories. Which means whichever candidate gets the highest number of votes will be elected. In this sense, if there are 3 candidates contesting election, candidate A is the winner, despite the fact that candidate A bagged states such as those smaller states with smaller population. Candidate C ideally should have been the winner because majority of the people supported him or supported her, because those states where we have massive population, those states supported the candidature of candidate C. But we follow proportional representation for this very reason, for president's election, to ensure that president is elected by the majority of the people. And we look at the total votes polled. Whoever gets the majority, which means more than half of the votes, that person is the President of India. And at the same time, population will be taken into account. How population will be taken into account? Because value of votes will be different. Value of vote of an MP and an MLA would be different. Value of vote of an MLA of UP and an MLA of Sikkim would be different. Why? An MP represents a larger constituency, a bigger constituency. An MP of Lok Sabha normally has 4 or 5 assembly constituencies under it. That means if UP has 403 assembly seats, in Lok Sabha it has only 80. That means 403 divided by 80, which basically means a particular Lok Sabha constituency would have 5, 6 assembly constituencies within it. Clear or not? Which means an MP of Lok Sabha represents a wider constituency, which means wider population, and MLA represents a smaller constituency, smaller population base. That is why the value is different. And what is this value? The value of a vote of each member of a state legislative assembly, of each MLA, is calculated by dividing the population, total number of elected MLAs into 1 by 1000. What is the total population of that state? Divided by how many total MLAs, elected MLAs do we have, into 1 by 1000. That's the value of vote of an MLA. Which means for UP, since the population is higher, value of vote of an MLA of UP is higher as compared to that of Sikkim. Why? Proportional representation system. Those many votes will be given to you as is your population. Higher the population, higher the value of vote. Lower the population, lower the value of vote. Similarly, the value of vote of an MP all the value of votes of all MLAs divided by total number of elected members of the parliament, which is 543 plus 233, because there are 233 elected MPs in Rajya Sabha. That is how it is divided. Total value of all votes, which is calculated here, divided by total number of MPs in parliament. That's the value of vote of an MP. Sir, can you illustrate it? Yes. Look at, for that matter, Andhra Pradesh. How many MLAs are there? 175. What is the population? This is the population. Divide the total population with the number of elected MLAs into 1 by 1000. What is the value of vote of an MLA? 159. That means from Andhra Pradesh, 159 into 175, because every MLA has 159 value, into 175 MLAs. That means from Andhra Pradesh, we will have 27,825 votes. Let's take the example of a smaller state such as Sikkim. It has 32 MLAs. This is the population. Divide the total population by the elected MLAs into 1 by 1000. That means value of vote of every MLA in Sikkim is 7. Value of vote of every MLA in UP is, where is UP? 208. More the population, more will be the value of vote of an MLA. And when we combine all these value of votes divided by the total number of elected MLAs, divided by total number of elected parliamentarians, that is the value of vote of an MP. And now election will take place, which means voting will take place. When voting takes place, for example, let's take the example of Sikkim. If in Sikkim, 20 MLAs voted for Shri Draupadi Murmu, and let's say 12 MLAs voted for Shri Yashwant Sinha, we don't say that Draupadi Murmu has won Sikkim. What we say, we add these votes. 20 into 7 is equal to 140. 12 into 7 is equal to 84. And this is how we'll calculate all these votes. We count all these votes. From Andhra Pradesh, how many did Srimati Draupadi Murmu get? From Uttar Pradesh, how many did she get? And then we add these. And then we add all the votes which were received by Yashwant Sinha as well. And then we look at parliament as well, because every parliamentarian will have a value of vote. How many votes were given to Srimati Draupadi Murmu? How many votes were given to Shri Yashwant Sinha? That's how we decide the winner. Whoever gets the majority of votes, more than half of the votes, that person is the winner. But sir, what is this population that is mentioned in the constitution? Is this the existing population figure, or is this an old population figure? The population figure of 1971 census. Why 1971 census? This is something that we will discuss in elections. And this has something to do with delimitation. Very briefly here, Constitution says after every census there should be delimitation. Which means after every census there should be reorganization of constituencies. Which means if the population increases, number of seats should also increase. Because as the population increases, the number of representatives representing these people should also increase. If today we have a formula, for example, that for every 1 lakh people there should be 1 MLA. If tomorrow the population changes to 2 lakhs, we should have 2 MLAs. If it changes to 3 lakhs, we should have 3 MLAs. That means as the population changes, there should be increase in the number of seats. How do we get to know when the population changes? Every census. Which means when the census was conducted in 1951, then 1961, then 1971, after all these censuses, we saw increase in the number of seats as well. Initially 489 in Lok Sabha, then it went to 513, then it went to 543 in 1973. After the census of 1971, there was an increase in the number of seats in Lok Sabha. It rose up to 543. That means as the population increases, there should be delimitation so that it leads to increase in the number of seats as well. Delimitation was conducted first after 1951, then second after 1961 census, then third after 1971 census. And in all these censuses, southern states, they saw that there is a pattern. Southern states such as Kerala, Tamil Nadu, Andhra Pradesh, Telangana, Karnataka, they saw a pattern. And they got together. So, do you know what's happening? So, what? We have done good in terms of we have controlled our population. But this UP, Rajasthan, Bihar, they have not controlled their population. If delimitation takes place, they would be at an advantage. How? Because as the population increases, the number of seats will also increase. Look what has happened. The number of seats have increased from 489 to 543. But we got nothing. It's the UP, Bihar, Rajasthan, these seats which have got increased representation in Lok Sabha. So we are being penalized because we are doing good. We are being penalized because we have controlled the population. These states are given incentive for not doing well. And what is the incentive? You will have more seats in Lok Sabha. They petitioned Indira Gandhi. Indira Gandhi said, yes, you are right. I will amend the constitution. Parliament got together, amended the constitution and said till 2001, there will be no further delimitation. Then in 2001, it was amended again. Till 2026, there won't be any delimitation. And the number of seats are frozen. That means after 1971 census, if 543 was the number of seats in Lok Sabha, this number remains frozen till 2026. Why 2026? Because this constitution was amended in 1976. In 1976, Parliament amended the constitution and said no further delimitation till 2001. And even if delimitation takes place, the number of seats will not increase till 2026, which means in these 50 years, 1976 to 2026, we may see our population stabilizing. That is why whatever the population figure was on 1971, in 1971 census, the same population figures will be used to calculate the value of vote of an MP and an MLA. But then you will say, sir, what about Telangana? It was created after 1976, after 1971 census. What about other states which were created after 1971 census? How will you determine their population? Andhra Pradesh was one. Now all the districts which are now part of Andhra Pradesh, all these districts put together, what was their population in 1971? That formula will be used. All the districts who are now part of Telangana, what was their population in 1971? That will be used to calculate the formula. For example, this is Telangana. It has 119 MLAs. This is the population of those areas which are under Telangana right now. And this was their population in 1971, which means every MLA has the value of 132 votes. This is what we call proportional representation system. Any questions as of now? That I don't know the answer to this question. So why would he ask this question? Delimitation will happen, may happen. There is no ban on delimitation after 2026. But what if government decides not to go ahead with that? Nobody can force them. So the president is elected by the electoral college in an indirect election through a system of proportional representation system, where the value of votes is calculated based on the population of individual states. Based on the populations of individual states in 1971, those many value of votes will be given to each MLA, which means the MLA of UP will have more votes as compared to MLA of Sikkim, because the population is different. Clear? And then any candidate who has to win this presidential election has to get the majority, which is more than half of the total valid votes. And for that, we follow something known as single transferable vote. And what is this single transferable vote? Let's say, for example, you are part of the electoral college. You are part of the electoral college. Okay. You are given voting ballot paper. This is your ballot paper. MLAs of Rajasthan will vote in the Rajasthan Legislative Assembly. So that once we count the votes of Rajasthan Legislative Assembly, we know what is the value of each vote of a Rajasthan MLA. Lok Sabha MPs will vote in Lok Sabha. Rajya Sabha MPs will vote in Rajya Sabha, so that we know what is the value of vote of each MP. Clear? Now, if you are part of the electoral college, which means you are the voter, you have to elect the President of India, you are given a ballot paper. On this ballot paper, on one side, you have the candidate, and on the other side, you have the preference. This is just a simplistic example, explanation, illustration of a ballot paper. Otherwise, it looks different. But this is just to make you understand. On one hand, you have the candidate. Let's say there are four candidates contesting the election, A, B, C, D. You have to give your preference. You say, my first preference is A, My second preference is D. My third preference is B. My fourth preference is C. You may not give any preference also. You may just give my first preference is A and then be done with this. Or you may give preferences as well. As many preferences as there are the candidates. Now all the voters will vote like this. Now when the counting takes place, we will first count first preference votes. That means how many voters gave first preference to A, what is their value? How many voters gave first preference to B, C, D, what is their value? And then take a look at the counting and see the final number. Whoever gets more than half of the total votes becomes the candidate, becomes the president of India. Clear? What if candidate A got 40% first preference votes? B got 30%, C got 20%, D got 10%. Who is the president of India? Nobody. Because we have to go by the majority. Anybody who gets more than half of the votes becomes the president of India. Here, nobody gets half of the first preference votes. Then what do? Who has got the least number of votes? D. D is eliminated. But what will happen to those people, to those voters who voted for D? If 10% people said D is our first preference, we have to then look at what was their second preference. So that those second preference votes would be transferred. And let's say 5% people said A is our second preference. 5% people said B is our second preference. That means those people who gave first preference to candidate D, since D got the least number of votes, D is eliminated from the contest. But those who gave first preference to D, what was their second preference? 5% of them said our second preference is A. That means these 5% would now become the votes for A. 5% for B. Now who is the winner? Nobody. Because even then, nobody is getting more than half of the votes. This is what we call second round of counting. In the first round of counting, we saw the first preference votes. Nobody got the majority. We eliminated the least possible candidate. In the second round of counting, we added the second preference votes of D to A and B. Still, we don't have a winner. Now we will count for the third time. Now, who has got the least number of votes? C is eliminated again. But those who gave first preference to C, what was their second preference? Let's assume all of them have mentioned in their voting slip that our second preference is B. Now, B has 30 plus 20 plus 5, which means 55% of the votes. B is now the next president of India. This is what we call single transferable vote. So that, as I told you previously, this president should be elected by the majority of the people. If majority do not give first preference to this president, at least they should give second preference to this individual. And once we have somebody who gets more than half of the votes, that person is the president of India. But this may be asked in your prelims, in all elections except one, president got elected after first round of counting. That means when we count the votes for the first time, we take a look at first preference votes. In the first round of counting itself, we have a winner, somebody who gets more than half of the valid votes. It was only once when V.V. Giri was elected as the president of India that in the first round of counting, we could not find a winner. We could not find a winner because nobody got more than half of the seats, half of the votes. It was only when we looked at the second count of voting, second round of voting, and we added second preference votes to these candidates, that we got the winner, VV Giri. Neelam Sanjeeva Reddy was the opposite candidate. It happened only once. Otherwise, in all elections, in the first round of counting itself, we have a winner. So the president is elected by the electoral college in an indirect election through a system of proportional representation system by means of single transferable vote, and then there is something called as secret ballot. You may have a question, sir, why don't we use electronic voting machines in president's election? Why do we use ballot paper? Why do we have to mark options on the ballot paper, then drop in the ballot box, and then one by one we have to count these ballot papers? We do not have an electronic voting machine to design this complexity. We have electronic voting machines to be used for Lok Sabha elections, Legislative Assembly elections, Rajya Sabha, Lok Sabha elections, Legislative Assembly elections. Rajya Sabha elections also is done by ballot paper, and I'll tell you why. And there, we just have to go, enter the polling booth, press the button, and then go. In these Lok Sabha or Legislative Assembly elections, we don't have to mark our preference. It's not that we have 20 candidates contesting the election and one by one I have to give preference to them. That my first preference is A, second preference is Z, third preference is P. There I have to vote and vote for only one candidate. And that is for that reason we have devised and designed the electronic voting machine. The electronic voting machines that we use currently is not designed to accept preferences. That is why for president's election, we use ballot papers, ballot boxes, and not electronic voting machines. And if this is the ballot paper that is given to you, you are a voter, you have to keep it secret. You don't have to reveal to anybody who did you vote for. So you make your preference and then secretly drop this ballot paper into the ballot box. If you reveal it to somebody, this vote is invalidated. When Pranab Mukherjee was elected as the President of India, Mulayam Singh Yadav, wearing a dhoti, walked and then showed it to the Congress party. See, I have voted for Pranab Mukherjee. Said, idiot, this vote is invalid. Why? Because the voting takes place through secret ballot. You can't reveal your preference to anybody. So President is elected in an indirect election by the Electoral College through a system of proportional representation system by means of single transferable vote through secret ballot. You can't reveal your vote to anybody. There may be another question on your mind. Sir, if Srimati Draupadi Murmu is the candidate and Shri Yashwant Sinha is the candidate, BJP's preference was Shri Draupadi Murmu. Congress's preference was Yashwant Sinha. Does that mean all Congress voters who are part of the Electoral College will have to vote for Yashwant Sinha? All BJP members will have to vote for Srimati Draupadi Murmu? What if a BJP MP or an MLA votes in favor of Yashwant Sinha? What if a Congress MLA or an MP votes in favor of Shri Draupadi Murmu? Can action be taken against them? Can action be taken against them? Question. Most of the students are saying no, some are saying yes. How can action be taken against them? Sir, why not? Because nobody would come to know who they voted for. This is secret ballot. If I am from Congress, I will tell Rahul Gandhi, Rahul Baba, I voted for Yashwant Sinha. I voted for Draupadi Murmu. How would he get to know? Because my vote is secret. That is why we say in presidential election, whip is not binding. Normally for voting, the whip is issued by the political party saying you have to vote in favor of this bill. You have to vote against this bill. If you violate this whip, you will be disqualified. But this whip, this directive of the political party, Congress telling its MPs and MLAs, you vote for Yashwant Sinha. This is not binding on these MLAs and MPs. Why? Because they will never get to know who they voted for, because the voting is through secret ballot. Done? Candidate vote of C whose second preference was D. You tell me what should happen. Nothing. Those votes will not be transferred because he is already eliminated from the contest. Just one preference as well. What if all get A, B, C, D got 25% votes? That will not happen. That is a statistical, very remote possibility. Then normally what we do, we use the draw of lots. For example, in Lok Sabha elections, legislative assembly elections, also in municipal elections, if there are two candidates and we have a tie, candidate A got 500 votes, candidate B got 500 votes, we have a tie, then who is the winner? I'm the returning officer. Who is the returning officer? Let's say if it is the Lok Sabha election, I am the district collector. District collector is the returning officer because I return the winner. Who is the winner? I decide it. How? When there is a tie, you got 500, this candidate got 500. I will mention both your names in two different chits. Pick one chit. This person is the winner. This person is the winner. Clear? That's how it is done. Proportional representation system. If there are only two and we need then 16 states, 16 seats, what if these 16 states are the 7 northeastern states, 7 sisters, plus Sikkim, plus Goa, plus Puducherry, plus Uttarakhand, plus Haryana, these smaller states. And the majority of the states which have massive population, they are backed by another candidate. It creates a situation where the president is elected not by the majority of the people. And that we will discuss tomorrow, how that is the discretionary power of the president. MP and MLA can simply mark only one preference like A as first and submit the ballot. Is it possible? Yes. Sir, due to surgery, I cannot attend the class. How do I cover the class? Cover through the recorded lectures. Binding in presidential election. We will discuss. Mains-based questions as well. That will be based on the topics that we have covered throughout the week. Start writing answers. Do it every week. Then Vice President, then Prime Minister, then Cabinet Committees, then Attorney General for India. And tomorrow we will discuss previous year's question papers as well. Don't miss tomorrow's class. It's going to be very, very important because from this topic, lots of questions are asked in the examination. See you again tomorrow. Till then, have a great time. Bye-bye. Goodbye.